Good afternoon, everyone. We are about to start the day 2 of our webinar, Development Projects in Sri Lanka, Better Regulations for Better Outcomes. Yesterday, we had a very fruitful discussion focusing on two regulatory frameworks that plays a critical role in determining the costs and benefits of large infrastructure projects. The legal framework governing the procurement and the legal framework governing involuntary resettlement. Today, we are going to discuss the regulatory framework governing the environment impact assessments of large infrastructure projects. EIAs play a critical role in ensuring that the infrastructure projects we are investing in are sustainable and inclusive and contribute to the economic growth and development of the country. Impact of large infrastructure projects on environment is a subject that has received much attention in the recent past. Given the impact such projects can have on the environment, it must indeed need even more attention. Large-scale development activities can potentially disrupt ecosystems, increase pollution, and exhaust natural resources, and affect the lives and livelihoods of local communities. It is for this reason that mitigating such impacts on the environment features prominently in infrastructure procurement discourse. In relation to this topic, the public in the recent past has raised two key questions on the impact of large infrastructure projects in Sri Lanka having on the impact they have on the environment. First, whether the impact on the environment has been sufficiently analyzed or assessed before making decisions to go ahead with these projects. And second, whether adequate measures are taken to mitigate the negative impact of these projects on the environment. To answer both these questions and to address both these concerns, the regulatory framework in the country plays a very, very important role. Therefore, we hope that today's discussion on the current regulatory framework, investigating its adequacy to address the concerns raised by the public, is a timely discussion. I would like to invite Jayasinha to present the part of his research. Over to you, Uween.
Thank you, Subhashini. Good afternoon, everyone. And thanks for the introduction, Subhashini. As Subhashini mentioned, what I will be doing today is basically going through the Sri Lanka's environmental impact assessment framework and essentially show how important an environmental impact assessment, the regulatory framework is when it comes to the development agenda of a country. And environmental impact assessments, or EIAs, are particularly important because it is actually one of the key or one of the primary clearances that a developer has to obtain prior to commencing a development project. So even before the procurement stage goes on, it is vital, or it is necessary under Sri Lanka's law, procurement laws, for the environment clearance to have obtained. So this is actually one of the primary clearances that a developer has to get. And we see that actually sets out the foundation for the entire the scope of the development project. And we say that is why environmental impact assessments particularly become important in the development agenda of a country. So my presentation will be structured in this way and basically broken down into 6 sections. First of all, I'll just very briefly identify what exactly an EIA is and what exactly its scope is. Second, I will be telling you why an environmental impact assessment is important and what purposes they exist to serve. Thirdly, I will be essentially talking about the parties that are involved in an environmental impact assessment, essentially sort of going through who the stakeholders are and what their roles are. Fourthly, I will just have a brief introduction into what exactly Sri Lanka's environmental laws are and what the scope of these laws are. Next, I will be just very briefly touching on what the benefits of including public participation as well as accessibility of information into the environmental impact assessment process. And finally, I will touch on some of the gaps and weaknesses in Sri Lanka's environmental impact assessment framework, particularly in respect of how our laws and our regulations don't necessarily have or don't necessarily encourage public participation and the disclosure of information, which essentially undermines the entire purpose of the environmental impact assessment process, as I will explain as we go along. So firstly, coming into what exactly an environmental impact assessment is. So the premise of an EIA is that environmental concerns, when it comes to a development project, environmental concerns are best addressed when they are identified and mitigated as early as possible. So the idea is that the earlier you know about a particular potential environmental impact, the more likely it is that you can actually exploit, evaluate it, and find better ways to mitigate it or find better alternatives for it. So essentially, what the EIA is a process of identifying, predicting, evaluating, and mitigating the various aspects or various environmental and ecological aspects concerning a development project. And basically, what is done by this is you're essentially trying to predict and try to forecast what exactly what essentially what the particular environmental impacts of a development project are. So moving on to why exactly environmental impact assessments are important, one of the key examples or one of the best ways for me to explain this to you is through the recent Umaoya project, not recent, but one of the Umaoya project in Sri Lanka. And this actually is one of the key examples that we could use to essentially show that that there can be negative consequences. There can be serious negative consequences arising when an EIA is conducted without public participation or in a way that's not exactly proper or not exactly meaningful. So what happened in the Umaoya project is basically it involved the construction of several dams that also involved a lot of underground drilling and sort of diverting water sources. But if you want to look at the environmental impact assessment that was carried out for the Umaoya project, you will see that a lot of the views of environmentalists, of experts, and even the communities were kind of ignored during the EIA process. You will also see that some of the impacts, such as the impacts of tunneling and underground water, the effects on underground water sources, hadn't exactly been, hadn't exactly been assessed in the EIA. And more, even if we were to look at the section on the exploration of alternatives, you would see that section was rather weak. And because of these key issues, we see that as a result of the Umaoya project, the areas around the Umaoya have actually had several ecological problems, such as drying up of wells, destabilization of soil, and drying up of water sources. And we say that the ecological harms have now almost reached a point where whatever benefits that could have been obtained from the Umaoya project may actually have been diminished to a great extent, because the resulting cost of not having properly considered all environmental impacts essentially negates whatever benefits that Sri Lanka stood to gain from the Umaoya project. So next, moving on to who exactly is involved in an environmental impact assessment. So in Sri Lanka, in quite a lot of places, there is a misconception that we as members of the public do not necessarily have the opportunity to get involved in the formulation of an environmental impact assessment. But if one were to look at the best practices, or one were to look at this idea of how EIAs are actually supposed to be conducted, you would see that EIAs have to actually be inclusive. And the idea here is that the more participation you have, the more likely it is that more information would be shared. And with more information being shared, you are more likely to have a better analysis or better evaluation of potential environmental impacts. And that can create situations where you have sort of better forecasting, better predicting of environmental impacts, and actually exploring better alternatives as well. So that is why the environmental impact assessment process should not strictly be limited to the developer and the government. It has to involve independent stakeholders, it has to involve experts, it has to involve the members of the general public or members of affected communities. So if I were to quickly just go through Sri Lanka's environmental impact assessment laws, so we see that there are 4 key laws that govern environmental impact assessments in Sri Lanka. The general law, like in any area of Sri Lanka where a large scale project is planned to be developed, the more it's more likely than not that the national environmental act would apply. But in the event that there are projects that are going to be carried out in the coastal zone, then you'd have the Coastal Conservation Act being applied, as well as if there are projects being carried out within 1 mile of any national park in Sri Lanka, you'd have the Flora and Fauna Protection Act being applied. And the northwestern province of Sri Lanka has its own environmental statute that also sets out an environmental impact assessment framework. So it's basically these four laws that set out Sri Lanka's entire environmental impact assessment framework. And what we've done in the course of our process is actually identify analyze these laws as well as the regulations that were passed under these laws, to sort of get a sense of how environmental impact assessments have been done, the procedures that are adopted, sort of the processes, the internal processes, administrative processes adopted by our institutions, and essentially to understand how exactly these laws stand up against not just best practices internationally, but as well as best practices or other practices of our peer countries, such as, say, Philippines, India, Pakistan, and even Kenya, which are all developing countries and have so much of the same geographical conditions as Sri Lanka as well. So moving on to what exactly the standard EIA process of Sri Lanka is. So while I said we have 4 laws and these 4 laws do have differences amongst them, sort of the standard process that is sort of adopted in Sri Lanka in preparing or sort of conducting an environmental impact assessment basically follows this standard, the standard 4 stages. It starts off with the screening, moving on to scoping. Then you have a public participation and technical review phase, and finally decision making. So essentially how it starts off is that the developer would essentially sort of seek approval. Then the project approving agency would determine whether an environmental impact assessment is required or not. Once it is determined that environmental impact assessment is needed, you would go into scoping, which is a process of sort of consulting all the stakeholders to kind of identify what exactly the potential environmental impacts are. And once all that information is obtained, the project approving agency will formulate the terms of reference, essentially containing what areas that need to be studied for the purposes of the environmental impact assessment. That would lead to the creation of the environmental impact assessment report. Thereafter, the report is reviewed by the public as well as the technical committee, and then the technical committee or the project approving agency would finally approve or reject the environmental impact assessment report based on the comments of the public as well as the technical evaluation review committee. So this is sort of the standard process that is applied. There are deviations based on the different laws that I mentioned earlier, but generally this is the standard process that is applied not just in Sri Lanka but in most parts of the world as well. So before I move on to my next section about sort of the gaps and weaknesses, I feel it's also important to identify or highlight one of the best practices when it comes to environmental impact assessments, and that is the importance of accessibility of information and basically public participation. So on my screen here, you will see Principle 10 of the 1992 Rio Declaration, which has been sort of currently sort of identified as being something of customary international law and something which even Sri Lankan courts have constantly relied on. So this best practice essentially states that the best way in which environmental issues can be handled is through participation and through the sharing of information. And the idea is that the environment is essentially a shared resource. It's a common resource that all of us have a stake in. And the best way to sort of get sort an issue that relates to a shared resource is through inclusiveness, is through sort of consultation, is through some level of dialogue. And that is precisely what the Rio Declaration also identifies and sorts to give effect to. So this is basically the best practice, and we sort of Our research was sort of premised on the idea that if we are to have good environmental impact assessment processes, we need to be able to evaluate how well our laws actually allow for public participation and how well they actually encourage or sort of ensure that there is accessibility to information.
I wonder whether we can pause maybe
Yeah.
and take quick questions, perhaps, because often when you do this kind of thing, there's a lot of clarifications without waiting the audience, making the audience wait for the end. Perhaps we'd open it out. I know some people are following us on social media, some are on this channel, and I think our team will highlight to us if there are any clarificatory questions that emerge. I think one question that's already been highlighted to me is a question of, when you do an EIA, does it have a use by date? Does it expire? Like, is it for a limited period? Or can you do an EIA today that's good for the project, for a 50-year, 100-year project? How does that work? Yeah.
That's actually a great question, Nishan. And to be honest, we don't really have a sort of system where environmental impact assessments have a sort of a best before date, so to speak. And if I think one of the best examples of that is if I were to point out to the Norachole EIA. That was conducted in 1997, even though the project was actually developed much, much later. There is a system of sort of supplementary environmental impact assessments being formulated in the event that there are new issues that come about. But yes, Nishan, that's a great question, and that is actually one of the weaknesses in our legal framework, because we don't really have this idea of ongoing environmental impact assessments. It almost is a system where once you do it, that's it, you go ahead with it. So that's a great question, Nishan.
Yeah. So I just flag one more clarificatory question that's come my way and move on. Does every project need an EIA? Who decides which project requires an EIA, which project doesn't? Or if you're doing a 10 million rupee project EIA versus a billion rupee project, so is there some cutoff either financially or otherwise? Yeah.
So that, Nishan, actually ties into one of Sri Lanka's bigger issues, one of Sri Lanka's bigger governance issues of this how discretion is sort of given sort of excessively. And if I were to point out to the in respect of the Coastal Conservation Act, the Director General has full discretion on what project would actually need an EIA or not. Of course, when it comes to the National Environmental Act, there are certain list of projects which have been identified by the environmental minister based on its magnitude and locations, and that sort of gives a fetter to the discussion and sort of ensures that there is some guidance given on how this discussion should be sort of exercised. But unfortunately, that applies only in terms of the National Environmental Act, and in terms of the other laws, unfortunately, it sort of appears to be at the complete discretion of the authorities. And we say that is also a bit of a problem, because that essentially can lead to an abuse of discretion.
So when do you become not included in the National Act? Like, is there a way that you say, look, I don't come under the National Act, therefore the discretion of officials can be exercised? Yeah.
So the only time that would actually come into being, Nishan, is of course there is also some discussion in essentially saying that if a project has a similar project has been done, then sometimes the Director General would have you could ask and say, look, I can rely on previous reports or previous studies, I don't necessarily need to do it. But of course, since EIAs are costly, I mean, there is possibly going to be a situation where developers would more likely push towards not having an EIA or trying to get lower level of environmental clearance. So that question, Nishan, is just a pure question of discretion, and essentially how the Director General is able to sort of interpret the regulations that I just spoke of.
Okay, sorry for the interruption, Uween. I
No
thought
problem.
that'll help.
Great question.
Please go ahead. Yeah.
So moving on to the second part of my presentation, where we will be identifying the gaps and weaknesses in Sri Lanka's environmental regulatory framework. So we identified two categories of gaps and weaknesses, and first relates strictly to sort of the limited availability of access to information, And the second one relates to the limited opportunities for the public to actually participate in the environmental impact process. And as I mentioned before, access to information and public engagement are sort of core principles or core values that undermine, that sort of underpin the effectiveness of an environmental impact assessment, particularly because environmental impact assessment is a predictive and sort of forecastive process. It requires the sort of the exchange of information, and if there are gaps which sort of limit the availability or access to information or your ability to participate, that actually can undermine the entire process. And just bearing that in mind, let's move into what these gaps and weaknesses are. So the first issue that we found was that there is a serious lack of information disclosure in Sri Lanka. So if I could just lead with an example which I'll try to use throughout the rest of my presentation. So say, for example, in your neighborhood, there was a coal power plant being constructed, and you are concerned about how exactly this coal power plant is going to affect your livelihood, it's going to affect your environment, and how it's going to affect your property. Generally, you would assume that because it's such a large scale development project and because it can have ecological impacts, that there would be some level of obligation for information to be disclosed. But the problem with Sri Lanka's laws is that not one of our laws actually have a proper or legal obligation requiring officials or the developer to disclose information. So there are quite a few key documents which my colleague Mathisha will also be highlighting later on, which are crucial to understanding how the environmental impact assessment has been done. And these include scoping reports, feasibility reports, technical committee reports, terms of reference, how exactly monitoring has done, your baseline data. All of these things are crucial to understand how exactly this environmental impact assessment has been done and how the clearance has actually been obtained. But we see that in Sri Lanka, because there is no legal obligation for information to be disclosed, there is actually a great difficulty in getting this information. And we've actually done empirical studies on this, and my colleague Mathisha here will sort of explain on that a little bit more. But even if us as just members of the public try to obtain this information, there's definitely going to be a lot of hardship in trying to obtain this information, and that can sort of severely undermine your ability to participate actively in the environmental impact assessment process. And the second gap that we identified is that Sri Lanka's laws don't require information pertaining to the environmental impact assessment to be published or sort of disseminated in a summarized or digestible form. And why we say that this is important is that, let's say, for example, like I said, there is a problem in your neighborhood, there's a coal power project plant that's going to be conducted, and you anyway don't have information, but you finally get your hands on the final environmental impact report. But the thing is, you are expected to read this extremely technical document, extremely technical and voluminous document. You're expected to read it, understand it, identify any issues in it, and thereafter make written submissions on why you feel that this document or this report has problems or has certain issues in it. And I just highlighted a few projects that we've actually studied, the environmental impact assessments that we've actually studied. And you can see that these are very bulky and it's a massive document. So for example, the Moragaha Kanda project in total is over 1,000 pages. And if one were to even look at it, it's filled with a lot of technical language, and you require a certain level of competence and expertise to actually understand and comprehend what exactly the EIA is actually trying to say. So the problem is, without an obligation to actually provide this information in a summarized form or in a digestible form, it doesn't make sense to actually even make this environmental impact report public, because the chances are that the average person or the normal person is not going to be able to understand it, even if they do get their hands on it. And this is actually, when we actually spoke to key informants about this, they conferred and they sort of concurred and said that, look, it is even organizations that particularly specialize in environmental issues have difficulties understanding what exactly is in an environmental impact assessment report. And this also is a significant contrast to how other countries other countries actually function, because we understand that in most other countries there's actually legal provisions for outreach activities to be done, and for information to be disseminated electronically through radio, through television, through news outlets. So we actually see that there is more public outreach and an actual meaningful, trying to create a meaningful way in which the public can be educated on what exactly the environmental impact assessment report says. So this is just a few examples of what the language of an average environmental impact assessment process in environmental impact assessment report is like. So this is the section of the environmental impact assessment report on the LRT project that was now scrapped, but nevertheless you can just take a look at it to understand how technical the language is. Again, here more technical language on this is an extract of the Moragahakanda project, the EIA that was conducted. Again, a lot of technical language being used. And finally, this is the Norachole coal power plant, the environmental impact assessment. Again, a lot of technical language being used, and sort of is evidence of the fact that it's going to be very difficult for a person without expertise to understand. So, like I said, when it comes to environmental impact processes, there is actually a possibility of the public being able to engage and review and evaluate and inspect a public environmental impact assessment report. But the problem with this process of actually inspecting an environmental impact assessment is that even though the public does inspect it and shares their comments with the developer and the technical evaluation committee, and then thereafter the developer actually responds to these comments, the response of the developer and the actual decision or the findings of the technical evaluation committee are not disclosed to the public. So it essentially means that, say, for example, like I'll go back to my example, you have a coal power plant project in your neighborhood, and you actually get a hold of the EIA, and you see that there's a problem here, and you actually submit a written comment based on an issue that you've identified. But once you do that, you will not get a sense of what exactly the developer has said in response to your comment, and you will not get a sense of what exactly the technical evaluation has said or how they have actually evaluated your comment against the response of the developer. So we see that actually undermines the transparency of this process of environmental impact assessment review. And that again has this effect of sort of undermining the public's ability to participate and engage with the environmental impact assessment impact assessment process. Moving on to the gaps and weaknesses in respect of public engagement. So, like I mentioned earlier, one of the key steps in processes in the environmental impact assessment procedure is what is known as scoping. That is whereafter it is determined that an environmental impact assessment is required, you'd have a set of meetings or basically a sort of a process by which you obtain information from various stakeholders. So that sort of creates an initial space for all relevant stakeholders to actually share their information, share their concerns about a development project, so that there can be information being obtained. And thereafter, after the scoping, that based on the information that you obtain during scoping, is when the terms of reference for your final environmental impact report is actually formulated. So scoping is actually very important for two reasons. First is that, like I said, it is the place where you initially gather information. And second, it's based on the scoping that the terms of reference are finally formulated. And for this purpose, scoping is generally supposed to be open, and any member, any expert, or any community leader should be allowed to enter scoping meeting and voice their concerns. But the problem in Sri Lanka is that scoping is only by invitation. And based on our studies that we found that in most scoping meetings, it's only government officials as well as the developer that are actually involved in the scoping. So you have the entire public who actually may have a lot of input to give, or experts not being part of the scoping, and that again undermines the ability for the public to participate. A second issue is that public hearings in Sri Lanka are not very common. Like I said, environmental impact assessment reports are complicated things, and it doesn't make sense for an average person or a person without expertise to actually be able to understand and make comments on an environmental impact assessment. And that is why in most countries you'd see that this process of public environmental impact assessment review is done through public hearings, because public hearings allow sort of give a space for people to actually lobby, to be able to have a dialogue, to be able to sort of have that sense of confidence that there are other people backing them, as opposed to unilaterally writing a comment or unilaterally writing a written submission to a public official. But in Sri Lanka, even though the law does, in some instances, provide for public hearings to be held, our findings we've realized in terms of our empirical studies that public hearings in Sri Lanka are hardly ever held. And even if they are held, there is no real way in which we can identify. There's no really any kind of pattern in which we can identify how exactly or when exactly public hearings are appropriate. It appears that public hearings are conducted purely at the discretion of the officials in charge, and that again is seriously problematic. And the final issue that we've identified is that when it comes to GRMs, that's grievance redressing mechanisms, we say that GRMs are important because they are sort of informal and administrative ways in which people can express their dissatisfaction when a decision has been given against them, or when a decision has been given outside of their concerns. But the thing is, when it comes to the EIA process, in the event that, say, an environmental impact assessment report is rejected, and the developer is the one who stands to be aggrieved, the developer has a direct appeal to the secretary of the ministry, an informal and administrative way in which he can ask the secretary, look, what, why don't you look at this again? There might be something that you missed. But in the event that the environmental impact assessment is approved against, say, the concerns of the general public, and the general public are the ones that are aggrieved, there is no such administrative GRM for the general public. And the only recourse that the general public is to go to courts. And we all know that going to courts involves a lot of other costs. There could be delays, there could be financial costs. It's a very formal, there are a lot of formal procedures, there are a lot of other complexities involved. So again, you sort of negate the ability of the general public to actually get involved and get engaged in environmental impact assessments. And that again undermines the overall ability for the public to actively participate in matters of environmental impact assessment. So through our research, what we've actually found is that in Sri Lanka, there is this common misconception that the more you have public participation, the more you have consultation, that it actually is problematic, or that it can lead to delays, or that it can lead to serious problems. But what we've understood, particularly through our research, as well as as everyone is aware of the various ecological impacts that are occurring in Sri Lanka, that is perhaps not the case, because if you actually do have public participation and you have sort of a meaningful engagement with the public, we see that when it comes to planning of development projects in respect of environmental aspects, you can actually get independent input. You can sort of get the local and indigenous knowledge. You can manage people's expectations and make sure that their tensions are less, and make sure that there is a sense of cooperation. And most importantly, it creates a sense of legitimacy in the eyes of the public that can prevent people from actually protesting or sort of showing opposition to development projects. And as we've seen in Sri Lanka time and again, when there is public opposition, when there is a lack of legitimacy, when the tensions are high, there are a lot of consequences that happen. We see that there are a lot of unforeseen environmental impacts that occur once projects have actually started. We all know of the case of the Central Expressway, where a lot of ecologically valuable trees were found in the path of the proposed pathway of the Central Expressway, which would perhaps lead to later adjustments. And there are countless examples in Sri Lanka where development projects have actually been delayed because there is so much of public opposition to them. So we say that by actually incorporating public participation, by sort of ensuring that there is a space for meaningful engagement, you actually can prevent more harms, and actually ensure that the process is more people friendly, is more public friendly, is more friendly towards local and indigenous communities. And we say that overall has a better impact in terms of, and can create a better outcome, a development outcome, than without public participation. So before I conclude, I just want to take a minute and ask if there's any clarificated questions that anyone has before I wrap up.
Actually, we haven't had any questions coming through, but
Okay.
certainly if anyone wants to unmute themselves and ask, please feel free to do that.
Okay.
You're welcome to ask a question. Until we see a question, or if you don't win, maybe you can advance us to the next slide and maybe introduce the report
Yes.
that's come out. Yeah.
Yes. So basically, my entire presentation is based on one of Verité Research's latest reports, where we look at the entire, where we study, going to and do an in-depth study on some of Sri Lanka's regulatory frameworks related to large-scale infrastructure development projects, where we cover aspects of procurement, environmental impact assessment, and involuntary resettlement. And you're all welcome to take a look at it and see how some of the various gaps and weaknesses that we've identified, and some of the proposals that we've sort of recommended to sort of ensure that there is better sustainability, better value for money, and better transparency in our entire development agenda.
Yeah, so
and yeah.
I just want to reiterate that presentations can only sort of scratch the surface, right, of what we write, and these presentations are designed to get you deeper into the question by sort of presenting the quick takeaways. In effect, what Uween's doing is the overall analysis on the legal side, on the informational side, but we do hope that you will, for those who are engaged in this area, that you will take the trouble to download the report, and it can act as a good reference document as well in thinking through the issues. So thank you very much, Uween. I haven't seen any questions coming up right now. We're going to then invite in half a minute Mathisha Arangala, who Subhashini introduced earlier, who's also an analyst on the economics team at Verité Research, to take us further into this question. I think Uween focused predominantly on the legal side. And what Mathisha is going to do, and while Uween looked at the laws and dissected the requirements of the laws and the ways the laws were set up to function or not to function, Mathisha will effectively set together the empirical sort of assessment we have, because a lot of this work is not born out of simply theory or opinion. It is something we test out by trying to get information and then documenting the way the gathering of information works. So I think the ease of accessing information and practice is Mathisha's presentation. And in this presentation, he will really break it down to saying, what is the possibility of getting information, because Verité put this to test, really. And I think this is a very important case study that then outlines the problem with regard to information and environmental impact assessment. So I will perhaps hand it over to Mathisha. Whenever you're ready, you can move forward. Yeah.
Thank you. So good afternoon to everyone. So I will be continuing with the next section of this presentation. As mentioned in the previous section by Uween and also as alluded to by Nishan, limited access to information is a key gap in the current EIA legal framework of Sri Lanka. And in order to empirically explore this point and assess the level of information disclosure in the EIA process in practice, Verité Research recently conducted a study which assesses the level of information disclosure and the ease of access to information on the EIA process of selected infrastructure projects. So if I'm to start off with the methodology of how we conducted this study, so just to give an introduction, best practices on EIA processes recognize that the public has a right to be informed early of projects that may affect them and in a meaningful manner. In fact, public participation in the EIA process is important for two key reasons. First, it helps in ensuring that the public can impact matters concerning the environment. And second, it can ensure that the decisions affecting the environment are transparent and accountable. However, to ensure that productive public participation takes place, it is important for the public to have access to vital documents relating to it in a timely and easily understandable manner. As such, to better understand this ease of access to information in the EIA process in practice in Sri Lanka, we investigated the availability of information related to 8 infrastructure projects which required conducting an EIA prior to its commencement. So these 10 projects are listed in this table. The projects selected were the highest value projects financed in the period 2005 to 2018 in the following 5 sectors: roads and bridges, energy, ports, railway, and water supply and sanitation. This includes 6 projects funded by China and 4 projects funded by Japan. So these are Sri Lanka's largest bilateral lenders for infrastructure development. And these 10 projects were implemented by 7 different government agencies. And of these 10 projects, 7 were approved by the CEA. The EIA was approved by the CEA. 1 was approved by the Ministry of Agriculture under the concurrence of the CEA. And the remaining 2 projects were under the purview of the Coast Conservation Department. So in order to assess the accessibility of information relating to these 10 projects, we sought access to 8 key documents that the relevant agencies are required to compile when following the EIA process outlined in Sri Lanka's legal framework. So these 8 documents are listed in this table. And if I'm to list out these documents. So one is the terms of reference, the EIA report, notifications for calls for public comments, and also notifications for approvals of the EIA reports, comments made by the public, responses of the project proponents to these public comments, environmental plans, monitoring reports, etc. So the analysis, in fact, looked at the ability to access these 8 documents online as well as offline. First, the availability of information online was assessed by checking the websites of the project proponent as well as the project approving agency of each project. And second, the ability to access information offline was assessed by looking at the response of the relevant authorities to the RTI applications filed with them. So if I'm to move on to the key findings, so the analysis revealed 3 key findings. First is that the general disclosure of information on the EIA process, both in terms of online disclosure as well as offline and reactive disclosure, is low. Second, accessing information via the RTI takes longer than the time prescribed by law. And finally, in certain instances, the cost of accessing information via the RTI Act can be excessive. So if we are to look at the first finding, so as noted previously, to assess the level of information disclosure of these 10 selected projects, we looked at both the online accessibility of the selected documents as well as the RTI responses with the relevant agencies of each project. And in all, we looked at 78 documents for the 10 infrastructure projects. That is 8 documents each for the 8 projects governed under the National Environmental Act, and 7 documents each for the 2 projects governed under the Coast Conservation Act. So these are specifically the Puttalam Coal Power Plant and the Hambantota Port. And here we looked at 7 documents because certain documents such as the approval, the notification for the project approval, are not required under the Coast Conservation Act. As shown in the graph, so the online if you have to first look at the online disclosure, the online disclosure information on the government agencies is very low. So what we found is that of the 78 documents that we assessed, only 4 documents were found online. And all these 4 documents were also found in the RDA website, where for instance, the EIA and TOR for the new Kanthi Bridge project was available, and the monitoring reports and the monitoring management report for the Southern Expressway could be accessed through the RDA website. It should also, however, be noted that the Central Expressway publishes EIA reports on their websites during the 30-day public inspection period. However, other documents which are vital part of the EIA process, such as the public comments, approval letters, and monitoring reports, are not accessible through the ECEA website. However, it should also be noted that the CEA has, in fact, recently set up an online repository of documents which includes the selection of past EIA reports. And previously, these reports could only be accessed by visiting the CEA library. So we should give props to this in the sense that it's definitely a step in the right direction in terms of enhancing information disclosure. But the records maintained in this repository are still incomplete and at times inaccessible. For instance, like while the EIA reports for some of the 10 projects we assessed are listed in the repository, when we try to download these reports, an error occurs. So that was our finding with respect to the online disclosure. Now, if you are to go into the reactive disclosure or the responses to the RTIs, So while we did receive more documents than what we could find online, we were still able to secure only half of the 78 requested documents through the RTI responses to the various relevant agencies. And it should be also noted that out of the vast majority of the information which was undisclosed, the documents which are undisclosed, so 72% of this undisclosed information was actually key documents that were critical to verifying the level of public engagement during the project cycle. For example, documents such as notifications for public to inspect the EIA report, public comments received on the EIA report, responses given by the project proponent to the public comments, public notification of project approval, these kind of documents were really hard to come by. In particular, the response by the project proponent to the public comments was available only for one project. And this document is especially important for the public to verify whether the concerns raised by them were adequately addressed by the project proponent, and also to assess whether the project approving agency has adequately considered their concerns. So non-disclosure of this information can really undermine the transparency and value of the public inspection of the EIA report, and thereby also reduce the public's confidence in the process. The key reason given by the authorities for not disclosing some of the documents we requested was that they were not in the possession of the documents at the time of the request. However, this raises two questions. First is whether these documents were available to the public even at the time the project was being developed and implemented. And second, are vital records pertaining to the construction and implementation of expensive and large-scale development projects not maintained by public authorities? So what we can understand is, okay, so the general lack of disclosure of this information was also confirmed by other stakeholders that we consulted. And while a certain degree of public disclosure of information is seen in the early stages of projects, it is not sustained throughout the EIA process. So the EIA report is the only document which is routinely made available to the public, as public inspection of the EIA report is mandatory. But the disclosure of other documents such as the TOR, fee feasibility reports, monitoring plans, etc., is quite ad hoc and inconsistent. The second finding of our analysis, our study, is the fact that accessing information via the RTI Act takes longer than the time prescribed by law. So even the legal information that we received through the RTI applications filed with the relevant agencies took considerable time for us to get them. According to the RTI Act, public authorities must disclose information requested within 28 days, unless an extension was requested for an additional 14 working days. However, our experience with the RTIs we filed was that on average, public authorities took at least 60 working days, which is approximately 3 months, to respond with at least a decision to provide the information. And as shown in this graph, only 5 public institutions out of the total 10 responded with a decision to provide information within 48 working days. We considered 48 working days as a cutoff period for this study, as due to in order to account for some of the inconveniences caused by COVID-19, because we conducted this study from August of last year till now. So in order to account for some of the COVID-19 delays, we considered the cutoff period as 48 working days. And what we can also observe from this graph is the fact that 4 institutions, in fact, took over 80 working days to respond, and for one institution, we are yet to receive the full information. So in conclusion, this excessive time taken to disclose these documents, even via the RTI Act, can seriously discourage the public from meaningfully engaging in the EIA process. The third finding is that the cost of accessing information via the RTI Act can be excessive at times. This was observed by us specifically with respect to the RTI file with the Sri Lanka Ports Authority. The RTI Act allows public institutions to charge administrative fees for photocopying documents containing information. And however, the regulations passed under the RTI Act also prescribe a standard photocopying rate of ₹2 per side of an A4 page. In addition to this, however, it should be noted that the regulations also allow for public institutions to continue operating any fee schedule that was already in existence prior to the RTI Act. But what we found was that of the 10 institutions with whom RTI applications were filed in the study, we were charged copying fees by 5 of these institutions. However, while 4 of the 5 institutions charged copying fees at a maximum rate of 2 rupees per side, we were informed by the SLPA that they charge at a tariff rate of $2 per side for the same information. So, which in rupee terms would amount to around 398 rupees. This is due to a prevailing photocopying rate that the SLPA had maintained before the RTI Act for issuing certified copies of SLPA documents to the public. And it seems as if this rate has now been extended to documents provided through the RTI Act as well. And this policy has been enacted as per the circular, which we are showing currently in the right-hand side of this slide, which was obtained as a response to the RTI application we filed with them. So while it's understood that charging a fee to cover cost of copying is somewhat justifiable on the part of the government agency, especially where there's a large amount of information which has been requested, the fee schedule charged by the fee schedule maintained by the SLPA seems a bit unreasonable, as it forces the public to incur significant cost to access crucial documents. So such price falls consequently serves as a further restriction to accessing information for the public, particularly if they are requesting for bulk information and a lot of data. So in conclusion, what the findings of the study point to is some serious gaps in the disclosure of information relating to EIAs in Sri Lanka. This can in fact result in some adverse outcomes on effective and meaningful public participation. For instance, difficulties faced in accessing information can incentivize public engagement and result in the public having to rely on information obtained through informal, unreliable sources. As such, the effectiveness of public engagement will also be reduced, and it would also create a lack of confidence among the public in the formal EIA process. This can in turn push the public to take alternative paths that are outside the law to highlight environmental issues and concerns. The overall consequence of this is that the public participation in the EIA process risks becoming a mere window dressing exercise. So Nishan, if you have any questions.
Mathisha. Thank you for that presentation. I think let's pause a second to see whether there are any clarificatory questions before we, maybe after that we'll take a break and come back to the panel. But I know that because we are on different channels, I just want to make sure that there is time for clarificatory questions. So let's just give it a pause and see whether anyone has any question that they'd like to raise. There doesn't seem to be many questions, Mathisha. There's one that's come my way, which is basically you highlighted, I think, 8 documents, right? That you looked at. Why did you was there some basis for selecting those 8? You told us the basis for selecting the projects, that they were the most costly projects since 2005. When you told us the documents are also critical. Why was it 8 rather than 7 or 9 or documents that you chose to look at?
So what we realized, when we went through the process, was that at each stage of the EIA process, from the scoping to the public participation, approval to monitoring, these are the key documents which sort of signify like a completion of each of the processes. So the terms of reference is this thing of the completion of the scoping period, then the comments, then the approval letters, then the monitoring reports. So that we felt like those documents are best signify the EIA process, and also they kind of also represent the compliance to the EIA process. So we thought that it will be better if we can get this information about these projects to get a better understanding of the. Yeah.
Super. That's very helpful. So I think before we take a break, let me try and perhaps, and I'll invite Subhashini later, I think, or maybe I can invite Subhashini now to kind of put these two together, because we've had 2 presentations where Uween talked about the legal problems of requirement to disclose, comprehensibility of disclosure, lack of availability of information for that public engagement and comments were not disclosed, so we don't know how they were responded to. And he went on to talk about, public things that were not done. Public meetings are not held, scoping meetings were not held, redressal mechanisms were not made known. And I think Mathisha really talked about three big issues, which is that both the proactive and reactive availability of information was rather low. Even on the reactive side, even with RTI law, we didn't get much of the information that we were supposed to get to. And it's not only that sometimes it may be because the information is not there, but actually they did not adhere to the law in terms of engaging with the RTI process, that it took so long. And that, we found the Sri Lanka Ports Authority, already deciding that the rupee wasn't legal, the currency they wanted to work in, and they want to price in dollars, being a government institution, and charging $2 aside for providing information, which perhaps is designed to simply avoid providing information, right? So once you put a fee like that, it's very difficult to, it's very easy to effectively tell people you're not disclosing information. And I think these are perhaps things that maybe have to be taken up in the RTI Commission, but discovering these problems, I think, that's of great value. And once again, there is another document here that is being highlighted called Wither Environmental Governance, which conveys most of this research and analysis. And I think this case study is important because everybody has complaints. Everybody says these are the difficulties we have. There's a kind of opinion in the country that information is hard to get, but documenting it in this way, in a systematic way of a case study, I think then makes it easier perhaps to look at how the government can formally engage and fix the problems. Subhashini, I'm going to just go over to you to kind of try and maybe also Subhashini was the research director overseeing all this research and very involved in it. So I just want you to give us some sense of meaning, after which we can take a break and come back at 3:10 for the panelists. Over to you.
Thank you, Nishan. Sri Lanka, most of the time, we tend to just resign and accept problems, right? We know, oh, so is it news? Information is not there. So what, right? The Taji is highly problematic. So when we do express anger in social media, in other forums about lack of environment compliance, I think one of the objectives of this research and this forum for us is to highlight we need to fix our systems, we need to fix our regulatory frameworks, we need to demand better compliance, more transparency, because these large infrastructure projects are undertaken by the government using public funds, saying that they are for the benefit of the public, then the public has the complete right to know and have the opportunity to give their comments and feedback. There must be formal opportunities. Right now, you have to go through informal channels. You have to have press conferences. You have to have, protests. All of these other channels are widely used simply because you don't have proper formal channels and there is less confidence in the consultations that are conducted. For us, I feel like we need to fix our systems, we need to fix our frameworks, and we need to demand this information from the government agencies. And disclosure of information to the public is to me is an effective means of reducing potential malpractices. And when there is visibility, it is the human nature. When we know we have high probability of being exposed, we are likely to be more compliant and better behaved. That is the human nature. So I think that is why public disclosure is very important, to make sure that our decisions made are made well thought through and well analyzed and is for the benefit of the people. So I think, though, I also must note that we do have many other gaps identified in the report. What Uween showed is just something we felt that it will be interest to the public, especially because this is an issue that has been of high concern to the public. And we thought we wanted to highlight about ability to access information and ability to participate as two of the gaps, but there are numerous gaps. And also, I think one of the more key gaps I'm sure the panel will also highlight is the time limits. So Uween said that these reports, EIA reports, the only report that is publicly disclosed, only report where people are asked to comment on, is highly technical and really long, large reports, but you're given only 30 days to read, understand, analyze, and submit written comments on this report. And to on large and complex infrastructure projects that can have enormous impact on the environment, that sometimes can outlast the benefits of the project itself, right? And the duration of the project itself. So this is important, and I think while we complain and while we need to also see, we need to fix these systems, and we need to, and I think public conversation and public demand is one of the ways where we can really nudge the government to really go to fix these problems for the benefit of the people. So over to you, Nishan.
Thank you, Subhashini. So let us give ourselves a 5-minute break and come back at 3:10, where the panelists will be introduced. And I think we have a very, very important group of panelists joining us today who are going to talk about their experience and what they've seen and done and known about the situation. It's Kanthi de Silva, Dr. Sumith Pilapitiya, Bhagya Vikramasinghe, who I will not introduce now, but will be introduced to you. And we will have about 1.5 hours, I think, after that, to engage in a discussion in which we'll bring out more aspects on this issue out and look at solutions as well.
Data is important because when we think about how we're governed, we want people to be really learning from the past in setting the course for the future. And data is the key ingredient, when properly understood, to make the best decisions for the future. Over the years, I've had to work with various data sets, but a key one has been on parliamentary data connected to the Mantri.lk parliamentary platform. In a nutshell, what it enables is for any person to find out what any MP has said on any issue in Parliament. It has been quite transformative in the way in which you can think through what actually happens in Parliament, and I'd encourage anyone who's interested to go and check out Mantri.lk. One example of parliamentary data being used in a transformational manner was when the then Minister of Higher Education went on to a political talk show and blamed the issues faced by universities on a particular students' union. However, the host had been to Mantri.lk and had got the information about what that particular minister had spoken of in Parliament. And then he turned around and said, "But Minister, on such and such a day, you had mentioned that actually the issue was because there were managerial issues within the ministry. So isn't that the actual issue and not the students' union?" For a moment, the minister's jaw dropped, because actually he was never used to being held to account for his utterances in Parliament. But it was actually a really good example of how data which is in the public domain, once it is processed through coding of parliamentary data and other things, can actually be transformative in how people are held to account. Many people ask, why should people seek data? I mean, first of all, I think we can all agree that this is just the way in which the data that is held by the state, which serves its people, can actually flow out. So using things like right to information is key. But I would also highlight one other really important point. You will realize that when you seek data, actually more and more information flows out. I can think of an example. When we were looking at Parliament and how data flows out of Parliament, before we knew it, people were saying, hang on a second, you're only looking at what happens in the main chamber of Parliament, but we do so much work in the committees of Parliament. We used that as an opportunity to say, but we don't have that information, make that public. Within 2 months, with the assistance of the Chief Government Whip and the Speaker of Parliament at the time in 2013 or 2014, all of that information flowed out. So seeking data actually has this cascading effect of actually getting more and more data as you seek and as you question more and more. So I would encourage people to not only use the information which is in the public domain, seek more data through RTI and other means that may be there, and you will see that actually a lot more flows out than just what you seek.
Do you have questions on Sri Lanka's economic outlook in 2021 and beyond? Have interest rates bottomed out, and when will they start rising again? Does Sri Lanka have a balance of payments crisis? And if so, what are the implications for the exchange rate? Does Sri Lanka have a path to manage external debt, and how feasible is this path? These are the types of questions that we address in the Verité Research macroeconomic briefing. This product is a structured macroeconomic analysis that is derived through a multidisciplinary approach. The briefing provides analytical foresight on key economic variables and the overall economic picture of the country. Our product is distinct from others since it is data-driven, independent, and takes into account political dynamics in the country. The product is available as a one-off briefing or as an annual subscription that includes 3 full briefings and an update each month. This product will be beneficial to all Sri Lankan firms navigating the challenging and volatile operating environment in 2021. It will be particularly beneficial for firms in the financial market industry, the boards of directors and corporate managements of those firms. It would also be useful for foreign investors and non-profit organizations looking to make an impact in Sri Lanka.
Thank you everyone for joining today. For our panel discussion, we have Dr. Nishan de Mel. Nishan de Mel is the Executive Director at Verité Research. He's an economist with extensive academic, policy, and private sector experience. Nishan taught and researched economics at Oxford and Harvard universities. In the 1990s, he sat on multiple presidential task forces in Sri Lanka, playing an instrumental role in designing national policies on health sector reform, social security, and tobacco and alcohol. Nishan completed his undergraduate studies at Harvard University and his graduate studies at Oxford University, where he was a Chief Winning Scholar. And moving on to the panelists for today, let me first introduce Mrs. Kanthi de Silva. She was the former Deputy Director General of the EIA Division at the Central Environmental Authority from 2004 until 2020. She served as a public officer for over 25 years as a regulator in the field of environmental impact assessments, EIAs, and involved with reviewing several EIA reports during this period. She's a chartered environmental professional and currently the Vice President of the Institute of Environmental Professionals of Sri Lanka. Moving on to our second panelist for the day, we have Dr. Sumith Pilapitiya. Dr. Pilapitiya is an environmental scientist with over 25 years of experience working in Asian and African countries on environmental, water resources, climate, and wildlife conservation. He is the former Director General of the Wildlife Conservation Department and the lead environmental specialist for the South Asia Environment, Water Resources, and Climate Change Unit at the World Bank Office for over 23 years. He is also a prominent figure on elephant conservation, an independent researcher on human-elephant conflict in Sri Lanka. And finally, let me welcome Mrs. Bhagya Wickramasinghe. Bhagya Wickramasinghe is an attorney at law and director of research and head of legal at EFL, Environmental Foundation Limited. She focuses on policy and legal research on climate change and environment, environmental rights, human rights, and sustainable development. Bhagya has an LLM in environmental law and policy from the University of London, LLB and LLM from the University of Colombo. Hello and welcome, dear panelists, as well as Nishan, over to you.
Yeah, so I'm moderating the session. I'm not going to try and beat the expertise of our panelists. I think who are very eminent sort of people in the field. And let me just start with perhaps Kanthi. Kanthi, just to kind of recap, and thank you for joining us today, by the way. You're the one person on this panel who's worked in the public sector, worked in government. So I'm going to kind of ask you a slightly uncomfortable question to get you going, though. I want you to start off with your prepared comments. All the things we presented today, in Sri Lanka in general, we think of politics as the problem. We blame politicians for all the problems we have in the country. And the role of a politician that we elect to parliament is to make laws. Now, the research presented today did say that, sometimes the laws are in place, and of course there are problems. The laws are not good enough. The laws are not updated enough. There are gaps in the requirements that are placed within the law. But also there's a second problem, that the laws are not adequately complied with by the bureaucracy. That the bureaucracy is actually not even doing the things that politicians have managed to pass into law. And it's almost like the bureaucracy is trying to, rather than serving the public, it's trying to hide from the public. There's that information disclosure is so very hard, so very disincentivized, even after our TI law. And maybe you have a more sympathetic view of the bureaucracy, and maybe we should understand the bureaucracy differently. I've had many letters of complaints from very good bureaucrats like yourself, when we come out of this kind of research saying, where it has been so unfair to us. We work so hard, we try so hard. And I think so your being here and speaking to us is, I think, especially important. We really value your views on this. Please let me hand it over to you, perhaps, and we'll come back with different questions as we go along. Yeah.
Okay, thank you, Nishan. And thank you for having me in the panel first. Now, having listened to the presentations, I thought of explaining the regulator's view of EIA, basically. I'll briefly explain the implementation procedure of each step of the EIA process, just to verify the limitations the project approving agencies or the regulators are facing in implementing the EIA procedure. Right? Now, in fact, actually, this is the EIA process starts with the receipt of the preliminary information submitted by the project proponent. The CA determines the requirement of EIA based on the list of prescribed projects published. So basically, there is no pressure for exemption of the project from the EIA procedure because there is a set prescribed project list. So what we have to do is just to check whether the project is falling within the list of prescribed projects published and determines the requirement for EIA. Right, but in case of coast conservation, as explained in the presentations, I understand that they always actually face a lot of pressures to exempt the projects from the EIA requirement, since there is no such list of prescribed projects published under the Coast Conservation Act. But they also usually follow the CEA prescribed project list as a guidance document, right? But the CEA or any project approving agency appointed by the CEA subjects preliminary information submitted by the project proponent to environmental scoping to set the terms of reference. So this is the first level of environmental scoping. We call it as the formal scoping procedure conducted by the Central Environmental Authority or any project approving agency appointed by the CEA. And again, you have to keep in mind, the CEA needs to issue the terms of reference after completion of the scoping procedure within a 30-day period. So time limit has been given to the Central Environmental Authority. The CEA conducts a scoping meeting and a site visit together with stakeholder agencies. These stakeholder agencies usually include the divisional secretary of the area and the chairman of the relevant local authority. So basically, the CEA conducts only one scoping meeting and one site visit. Usually, as explained in the presentations, the general public is not invited, not because the CEA does not want to disclose information, but due to practical difficulties, right? Because within this 30-day period, it's very difficult to invite all these stakeholder general public and get their observations. But perhaps sometimes if there are any community leaders, we may invite the community leaders for the scoping session. And in addition, during the site visit, the Central Environmental Authority officials and other stakeholder agencies used to speak to the neighboring community and get their views also. But what I feel is actually there was a suggestion to include the general public during the scoping process also. But what I feel is there is also a disadvantage of inviting the general public and disclosing the preliminary information to the general public, because there's a risk of misunderstanding which can be developed if the preliminary information is disclosed, since the preliminary information is not the final project proposal, and it may subject to different various changes during the EIA study. And the EIA report contains, and only the EIA report contains the final project proposal, right? In the TOR, usually the terms of reference is prepared by the project approving agency based on the findings of the scoping session. So the TOR contains the information requirement which need to be included in the EIA report. But again, what you have to keep in mind is TOR is only a guidance document, right? It is flexible. So the EIA consultants are not required to confine only within the limits of the TOR. So the EIA consultants are required to carry out further informal scoping sessions, right? So this you have to keep in mind. They are required to carry out informal scoping sessions and consult the general public in carrying out the EIA study and to further identify any additional issues which have not been included in the terms of reference. So that the TOR can be amended at any time if the consultants find any new important aspects during the study. So therefore, consultants cannot omit important aspects just because they are not included in the terms of reference. So it's the responsibility of the consultants to identify, further refine the issues. The TOR is also not a confidential document. I have to say that. But it's true that there's no formal procedure of publishing the terms of reference, but the terms of reference should be attached to the EIA report always. So it is actually published together with the EIA report. So upon receipt of the EIA report, the project approving agency within the 30 days, in fact, actually within a period of, again, a certain period to give approval for the project also. Now, what I want to tell you is, now the EIA report also needs to be submitted in all 3 languages, not only in English. It has to be submitted in English, Sinhala, and Tamil languages also. It is a must, it's a mandatory requirement under the EIA regulations. First, the project proponents are requested to submit a draft EIA report, and then the project approving agency determines whether all required aspects are addressed in the draft EIA report. And then we give one opportunity to the project proponent to amend the EIA report if the report has not addressed adequately the requirements. So then once the final EIA report is submitted, we will keep it open for public review of the EIA report, right? So we select convenient locations to keep the EIA report and make arrangements to keep the EIA report for the general public to refer, right? So usually we keep the EIA reports at the divisional secretariat office or the this Pradesh Sabha office or any office which is close to the project site. In addition, the EIA reports are also available online and it can be accessed through the CA website. At present also, there are 2 EIA reports available on the CA website. One is about this controversial Muthrajala film project, and there's another one about the industrial estate at Hambantota. So you may have noticed that the people have utilized this opportunity given to them. That is why there are so many now protests and there are so many complaints about the project. After reading the EIA report, they have realized these issues, right? So then after the public commenting period, all public comments received by the project approving agency will have to submit these public comments to the project proponent for their responses. So the project proponent needs to respond to these comments as much as possible. And once the responses are received, these responses will be sent to the general public who have made the comments. It's not correct that we don't actually open the responses received from the project proponent. We send these responses to the general public who have made those comments, right? But there's an issue. We don't check whether the general public is satisfied with the responses because we can't go into that depth. But instead, during the review procedure, we review whether the public comments are reasonable and whether the reasonable responses have been submitted by the project proponent for the comments, right? So once the public commenting period is over, then the Central Environmental Authority appoints a technical evaluation committee, which comprises of all stakeholder agencies, and in addition, some independent experts also to get the independent view, right? on various subject areas. So basically, the Technical Evaluation Committee reviews the EIA report as well as the public comments and the responses received from the project proponent for the public comments. So during this review, the Technical Evaluation Committee will thoroughly check whether the complaints or comments given by the general public are reasonable and whether the project proponent has responded to these comments fairly, right? But with my experience, what I can say is usually the general public is not interested in providing the comments if the project does not directly affect their property, right? So general public is not interested in providing information or commenting on the report on general environmental aspects. So basically, after the technical evaluation, completion of the technical evaluation committee procedure, so the technical evaluation committee prepares a kind of a technical evaluation committee report. So this committee report contains all the comments given by the technical evaluation committee members and the recommendations of the technical evaluation committee members. So based on the recommendations of the technical evaluation committee, the management of the CEA takes the decision whether to grant approval or reject the project. Usually, if approval is granted, is granted together with the conditions. Conditions include the mitigation measures which need to be implemented by the project proponent during implementation of the project. So then after the approval is obtained, the project proponent can implement the project. But again, I have to tell you that the project proponent usually believes that once the approval is obtained, that is the end of the EIA procedure. But that is not the end of the EIA procedure. So during the implementation of the process, it has to be monitored to check whether the compliance are met and whether there are any additional environmental impacts which have not been predicted in the EIA report. Right, but I have to actually admit that there is a lacuna in the law about the monitoring procedure. The law has not clearly specified the responsibilities of the project proponent with respect to the monitoring and implementation of mitigation measures. Right, we know that the mitigation measures are required to be implemented, required to be addressed in the EIA report. But basically, in an EIA report, we can expect we get only the general statements with respect to the mitigation measures. We don't get detailed action plan of implementation procedures, right? In fact, actually, we can't expect these kind of details also in the EIA process because these details are not available at the time of preparation of the EIA report because the detailed designing hasn't yet been carried out, right? Because of that, we usually request the developer to submit a detailed environmental management plan during the detailed designing stage of the project. But basically, the problem is even there is no such requirement of submission of a detailed EMP according to the law, and the developers are also not very interested in submitting such a document. So that is a serious issue we are facing. Without a proper EMP, actually the contractors who are really implementing the project are really not aware of the mitigation measures which need to be implemented at the site. And even the authorities are facing serious issues. They can't, in fact, actually carry out effective monitoring procedures without a proper detailed environmental management plans. So basically, these are the procedures we are facing now. In fact, actually, what I want to now highlight about certain issues. Now, in fact, actually, though there are so many negative issues, there are some positive issues also with respect to the EIA procedure. We know that the EIA procedure has evolved since its inception in late 1980s and is being implemented throughout the country for all development projects with the state agencies taking the lead. Right? We know that all development projects which fall within the prescribed list are, in fact, actually following the EIA regulations. So the EIA process has been recognized by the society as a sustainable development tool, despite having some limitations. We have to admit that there are limitations, but still the society accepts the EIA process as a sustainable development tool. The EIA process has provided a mechanism for integration of environmental and social aspects in development initiatives, to at least to a certain level. Right? And the other one is the EIA process has given communities and citizens an opportunity to voice their concerns in decision-making of development activities, though there are complaints that this public consultation is not adequate enough. And the government, from the government side and from the project proponent side, they believe that the EIA process is a very cumbersome and time-consuming process. And from the general public, the CA receives, what the complaint CA receives is the EIA process is not effective enough. So those are actually various the different kind of opinions we always receive. But I have to say this again, many of the EIAs have not, though the system actually, though the EIA is kind of a system which has been accepted by the society, we have to admit that many of the EIAs have not been able to provide environmental sustainability as expected due to various issues in the system. And as a result, the success of EIA implementation has been less than satisfactory. I have to admit this. So EIA report quality has been identified as a major implementation issue among other issues. So therefore, the main issue is what I feel, as I understand, the main issue is not the level of information disclosure, but the quality of information disclosed. We feel that there is enough, actually, the mandatory public consultation period is enough for the general public to submit their comments. But the problem is the general public cannot effectively utilize this mandatory public consultation period due to this bad quality EIA reports. They can't understand the EIA reports because they are too bulky, too technical, and contains a lot of irrelevant information and lacking many important information. Right? The main reasons for this, actually, the issue appears to be that one is the project proponents' attitude. This is a serious issue. Many project proponents consider EIA as an approving tool, and they do not consider it as a planning tool. Essentially, EIA is a planning tool, but this concept has not been actually absorbed by the project proponents. They always believe it as an approving tool. So that is why they want to do a kind of a shoddy job in a rush and submit the EIA report to get approval. And once the approval is obtained, they forget about the recommendations given in the EIA report. So that is actually one of the issues we are facing. And then, of course, actually, the consultants are always actually complaining that the data is lacking in Sri Lanka. There is no system in the government agencies that collect and compile the environmental data. So they always have to collect primary data while they're carrying out the EIA. So it takes years to collect certain data. And the poor impact prediction is another thing what we have noticed. In fact, actually, the impact prediction is the most important section of the EIA process. But what we have noticed is the full impact prediction is not given in many EIA reports. It's very difficult to get an idea about the real impact which will happen after implementation of the project. Because I believe that that is due to the lack of competency among the EIA consultants to carry out those kind of activities, right? And the other thing is impractical mitigation measures which are included in the EIA reports. So we can discuss these things if there is time. And then again, this is another important aspect actually. Then again, we are having a serious issue with respect to the inadequate environmental management plans, lack of post-approval monitoring and enforcement. This section is also actually, this step is also very weak in the EIA procedure. As I told you at the very beginning, the environmental management plan should be included in the EIA report, but in the EIA report, we get only general description of the mitigation measures. We don't get the implementation plan of the environmental mitigation activities, right? Without these EMPs, it is very difficult to carry out the monitoring activities in the site, and even the consultants, even the contractors who are carrying out the project at the site are not really aware of the environmental mitigation measures which need to be implemented at the site. Thus, the EIA recommendations are not properly transferred to the contractor. So this is a serious issue with respect to large-scale projects, because we issue the environmental approval to the government to the agency who is actually who is proposing the project. But in case of, I'll take one example. In case of a highway project, the project proponent is always the Road Development Authority. So we issue the environmental approval to the Road Development Authority. But the Road Development Authority employs certain contractors to implement the project. The problem is that RDA is usually not transferring the environmental approval and the conditions of the environmental approval to the contractors. So the contractors are totally unaware of the EIA recommendations and the approval conditions. So that is actually another issue. And in addition to these two issues, there are some two fundamental issues. One is, in fact, actually the lack of integration of this EIA recommendations in the project proponent's own project proposal. Because this is happening because the EIA, by the time of the EIA approvals are given, the project design has almost completed, and the site of the project site has been decided. So there is very less opportunity to make certain amendments after that. And there is another very, very important aspect I have to tell you. Now, the EIA process is being used to resolve many issues other than environmental issues. This is one of the biggest issues faced by the Central Environmental Authority. Because now you have to understand that environmental impact assessment discusses only about the environmental issues. The CEA cannot consider the feasibility issues, technical feasibility issues, or economic feasibility issues, because it's not the mandate of CEA to look at these aspects, and the CEA doesn't have competency even to check these economic and technical feasibility aspects. But as far as I know, there is no established procedure in the government sector to assess these kind of technical feasibilities and economic feasibilities. So this, of course, is a serious issue. So I will actually stop my description at this point, and we will face the questions. Okay. Thank you.
So you highlighted the 30-day rule earlier as a problem, that because of 30 days you need to have enough actual public consultation.
Yes.
And you also said the quality of public engagement is low, that they don't give you enough information.
Yes.
The presenters said, well, that's the 30-day rule is very hard because you can't turn around information in 30 days. So is that something you'd advocate change on with regard to the 30 days? I wasn't quite sure how you ended on that question.
Yeah. This is a problem because at present also the government believes that the EIA process is a very cumbersome procedure, and it causes a lot of delays to the development projects. So the CA is a bit reluctant to further, do something to further to make the process further cumbersome. So I don't believe that the CA will consider extending the public commenting period.
I understand. So basically, you're saying the tension that you face between those who think this should happen faster versus those who feel that this should happen better is a difficult tension to straddle. And I think you really enlightened us a lot on the particular approach, the approving tool versus the planning tool approach taken, and of course the monitoring and evaluation and the lack of that and how that follows. There are lots of other questions from the audience which I'm going to take later. Shall we move on to Sumith Pilapitiya, who's with us? So thank you, Kanthi. We are not finished asking you questions, but we'll certainly come back. And I really found the kind of the light you shed on the issue very helpful, I think, and it's really great to have. I know we spoke to you a lot during the research as well, but I think it was really helpful to hear you directly. Sumith, can I just invite you, because you've been listening to all this, and I know, and Sumith also worked, I think, well, not only in the World Bank, but also with government quite closely for a while. So he has experience from all sides, I would say, and is one of the most recognized people acting in this sphere. So would be very glad to. Over to you, Sumith.
Thank you. Can you hear me? Okay. Thank you very much, Nishan, and thank you for the presentations that were made. I think this the study that you are doing is extremely useful and very valuable. It's unfortunately Sri Lanka was among the first countries in South Asia to initiate a EIA process long before other South Asian countries did. So we were trailblazers when we did it. Unfortunately, what has happened is, in my opinion, we have regressed a bit from that point. Because while there are lots of issues that we have been discussing, and Kanthi knows for sure, because I have been having many discussions with Kanthi when she was in the CEA about this. At the officials level at the CEA, they are very committed to try to improve the process. But in a government agency, since I worked there for a very short time, I will tell you, unless there is political commitment or political will to make a change, it's very limited things that officials can do. So one of the biggest problems that the CEA faces, and people like Kanthi who were there, who were genuinely concerned and wanted to try to improve the system, faces is they don't have the commitment from above, the political commitment basically. That is where she said even the 30-day issue, I personally think 30 days may not be even long enough, but I know the pressure they are into to try to reduce it to 14 days or 15 days, right? So, which also goes into the point that I was trying to make on this, whether if we are really looking for better outcomes of EIAs, the question is whether we in Sri Lanka are achieving the objectives of doing EIAs. Because in my opinion, I don't really think we are achieving any objectives of the EIA, or not any is wrong. I think we are achieving only a limited set of objectives. So let me focus a little on what an EIA really is. As Kanthi also mentioned, it could be a bureaucratic tool, or it can be a very powerful planning tool. Unfortunately, we in Sri Lanka look at this as a bureaucratic tool. I think more than virtually 100% of the project proponents, public and private sector, look at the EIA as a bureaucratic requirement, and all they are interested is in to getting their project approved. That is why as soon as the project is approved, they forget about the EIA mitigation measures or anything of the sort. So if that is the case, we could ask ourselves, why in the world are we doing this EIA? It's a nice paper document. Has it really been implemented properly? Or it has been implemented to a very small extent, in my view. It can believe in the spirit of an EIA rather than only the bureaucratic aspect. Because in most projects, particularly large-scale government projects, the project is conceptualized, project is planned, detailed engineering designs are done. If it is a private sector large project, the land is purchased, or if it is a government project, the cabinet of ministers have approved the location for the project. When the EIA is done, you are now boxed into a corner because you have decided on everything else, and now you are doing an EIA basically to try to justify this bad decision you have made. So that, I think, is a fundamental problem that we have to address, because I will give some examples so that you realize what I'm saying. If a poor site is chosen, in order to satisfy the site analysis requirement of the EIA, the project developer chooses two worse sites and does a comparison between the two worse sites and the bad site. And obviously, bad looks better than worse. And that is what the EIA recommends to do. Right now, let's take the Matala airport, for example. My first question is, what was the basis for Hambantota district being selected where to have the airport? That was a political decision. So you start off with a wrong political decision that you are going to have it in a particular district. So now you're confined to options within that district only. So initially a site was chosen. Hambantota district also is a district that has about the largest number of protected areas in Sri Lanka. So a site was chosen which had to be changed due to environmental opposition because of it being too close to Bundala National. So this was one of the few projects that another site was asked to be, the CEA succeeded in another site, forcing the project proponent to look for another site. Unfortunately, in my view, the second site was a worse site than the first one, because the human-elephant conflict impacts that have resulted from the Mattala site is worse than the impacts on birds from the original site. But even the minister in charge at that time, because I spoke to the minister, asking him, this is a worse site, shall we try to do something about it? And he said, see, I managed to change it once with the political higher-ups. I will not be able to change it again, so there is no point, we have to go ahead with it. So you are taking bad decisions and making it worse as we go on. If you really wanted to have an airport in the southern part of Sri Lanka, a proper site evaluation should have taken place. Had that been done, many of the problems that are being faced, environmental problems, human-elephant conflict problems that are being faced in the Mattala area today would not have been faced. The case in point is that about a 100-day protest of farmers about the declaration of the managed elephant range. That the managed elephant range was an area to compensate for elephant habitat being taken away from the airport, and that has been, because now that has been taken away, the managed elephant range land is being given out for other activities, so there are huge HEC issues there. Then most of our EIAs focus largely on environmental impacts of the construction process. We are not looking at the cumulative impacts, are either marginally considered or not considered at all. For example, if you take a private sector activity, okay, we have the prescribed list says if it's less than, if I remember correctly, less than only more than 100 rooms, you have to do an EIA, full-blown EIA. So what do? We have 98 rooms in about 3 or 4 blocks next to each other. The cumulative impact in that environment is quite significant. So developers look for loopholes in the prescribed list. But I tend to agree with Kanthi that if you have a prescribed list, you reduce the discretion given to a public official, because if discretion is given, like in the Coast Conservation Act, political pressure can also be put to change what they're doing. If you take, when I'm talking about looking at impacts beyond the cumulative impacts of a project, if, for example, there are irrigation reservoir rehabilitation projects funded in the dry zone. There's one project I'm talking about funded by an international development partner. Now, if you rehabilitate tanks, you're going to have more water storage. More water storage means more land coming under cultivation. More land coming under cultivation means possible encroachment into state forest lands. That means encroachment into wildlife habitats. Then more water also means increased positives of increased yields, which are attractive to elephants. So you have increased human-elephant conflict. So I'm not saying you shouldn't be doing projects like that. All I'm saying is that if you're doing a project like that, if HEC is increased as a result of tank rehabilitation, shouldn't the development project be responsible for HEC mitigation? So HEC mitigation of that should be included under the tank rehabilitation project. This particular project I'm talking about is about a $250 million project. And we actually calculated HEC mitigation for the downstream impacts. It is going to cost less than 1% of the total project cost, less than 2.5 million. For a $250 million, adding 2.5 million more to make sure that extended environmental impacts or wildlife impacts are covered is nothing. But once you create the problem and then you expect the wildlife department to try to solve the human-elephant conflict problem, $2.5 million to invest to mitigate human-elephant conflict for that project alone is a huge amount for a department, conservation department. So what we are arguing is that mitigation costs also, this extended mitigation cost should be part of the project development. If we start thinking like that, then we are trying to actually capture the real objectives of the EIA. Because the EIA, as Kanthi mentioned, is one of the most powerful planning tools. And in my opinion, the EIA is a process. It's not a one-time thing. For large-scale projects, I think, see, we are living in Sri Lanka, so we have to accept the fact that political decision-making will take place. But I think political decision-making should stop at the project idea stage. Okay, like if they want an airport in the south, okay, that is the political decision. You want it in the south. Then let science and the institutionalized process take over. There should be no pressure on the Central Environmental Authority to cut corners. And even though Kanthi didn't mention it, I know that the CEA is put under tremendous by political authorities. Sometimes even the CEAs managed at the higher levels to tend to compromise on approvals of government-funded projects. That pressure doesn't come on private projects. It comes only on government projects. And that is the danger, because government projects, large-scale government projects, are the most environmental damaging projects in my view. So the EIA should be started at the conceptual stage. Making major changes is possible, and I said it's a process. So you start doing the EIA related work at the conceptual stage, and you keep modifying the EIA until you have made your final design, taking into account the environmental and social impacts. If you start doing that, then you end up with a better project. And this is the stage to get communities involved and start a dialogue with them without having formal meetings at the very early stages. Have a dialogue with them. There are other countries, even in South Asia, that I have worked on when I was in the World Bank. The dialogue actually is beneficial to the developer. In Sri Lanka, we feel that the dialogue is not beneficial to the developer, that the dialogue is really harmful to the developer. The communities will try to sabotage the project. Actually, South Asian communities think very much alike. And if it can be done in other South Asian countries, it should be able to be done here as well. And I'm trying to rush through because I'm taking too much time. But if the environmental and social mitigation costs are too high, then conceptual, locational, and design changes can be made at that conceptual stage. But once you have spent all the money, when you have spent money, invested money on detailed designs, it's difficult to change. So it's that early stage you should be looking at the environmental, social mitigation and the costs, and then making decisions. And if there is social impacts, the compensation should be agreed. So the environmental, social analysis and the economic analysis, which should not be part of the EIA process, should be done collaboratively, so that the economic feasibility of the project and the environmental, social feasibility coincides at some point and a decision is made. That needs to be done, and it is sad because under a USAID funded project, a system was developed in 1995 for the EIA and the economic assessment of the project done by the National Planning Department for government projects, and the EIA done by the implementing agency or the project proponent agency, to go in parallel and a final decision to be made. It was a very important and useful document, but like all good things in Sri Lanka, it gets shelved without a decision being made. So if we actually start doing things like that, we will make projects much more viable. So I will stop at that because you can talk for hours on this, but I think this in a nutshell captures that we have not really understood the real value of an EIA. We are only looking at it as a procedural requirement. That is a lose-lose situation, not only to the environment and the communities, but also to the developer. If the developer takes these concerns into account at the early stage, it will cost him less during implementation with protests and the construction being stopped and paying the contractor damage for delaying. All that is stopped if they do it right. Unfortunately, we don't seem to want to do it. We are only looking at it as a procedural requirement. I'll stop here. Thanks, Nishan.
Thank you, Sumith. You've kind of underscored, I think, some of Kanthi's points that that this requires a different process in a way. And I think it's building up that there is I think the presentations in a way argued that the system itself is not working, that you need to change the system. And I think Kanthi pointed to ways the system can improve. You've highlighted ways that the system can change. Can I just ask you, because you've been part of the World Bank for a very long time, you have, in a way, some sight of how it's perhaps done in other parts of the world. Are there models outside Sri Lanka that are getting it right in your view? And what are the sort of major areas in which you would see a discrepancy between how Sri Lanka is setting about its EIA process and perhaps some other jurisdiction that you would think we can try and emulate in that respect? Yeah.
Well, I think the way certain Western countries do the EIA process is much stronger than what we do, but that is impractical to try to replicate it in a South Asian or South Asian context. But there are countries within South Asia, some projects in India, some projects in Bangladesh, in Nepal, some projects in Bhutan that take this into account properly. The fundamental difference is, Nishan, that in those countries, there is much more political will to actually do the EIA process properly. In Sri Lanka, while the bureaucrats and technocrats at the Central Environmental Authority and other regulatory agencies are getting more and more savvy on how to do EIAs well, the political will on how to do EIAs properly is deep. So when there is no political will, the changes cannot be made. Now, the World Bank, Kanthi knows, I think about 10 years ago, did a study review of the EIA process of Sri Lanka, identifying things that need to be changed. But neither could the World Bank or the officials of the CEA get the hierarchy to want to seriously look at an evaluation of the EIA system in Sri Lanka and make changes for the better. They are very ready to make changes for the worse, try to reduce the time involved, reduce the evaluation analysis. For that, they are more than ready to do. And most of the time, we really blame the officials. But having, I think from the 1980s, I have been dealing with the CEA officials. And there are many officials who are very committed to want to do a good job. Their hands are tied. You put them in a straitjacket and tell them to do something. And once you're in a straitjacket, there's very little you can do. And then we criticize them saying that the CEA is not doing its job properly. So that's where some of these. So there are enough models that we can take, but we need to have the commitment to want to do it.
Thank you, Sumith. Let me move on to Bhagya. And of course, there will be some differences in view, I think, sometimes with Bhagya and others. And I think that's a very productive thing to create some conversation within the panel. Bhagya, I want to also, just in passing the baton over to you, kind of highlight a sort of challenge that comes perhaps your way because you're involved with the Central Environment, the Environmental Foundation. You're part of the civil society sort of dynamics in Sri Lanka that help people understand environmental impact and sort of go between government and society, which is a very, very important position to have. But, Kanthi says, one of the disadvantages of public consultation, she said, if I heard her right, was that public don't really understand the EIA. And she said partially that's because they're written in very technical ways. But perhaps she's pointing to failures of organizations that exist in civil society to make sure the public don't misunderstand. So I think perhaps the subtext of what she said is public you don't understand and unnecessary conflict emerges. Was perhaps Shanti's point. So I know you have some prepared thoughts, which I don't want to take away from, but I want to also present this challenge to you towards the end, perhaps, or at some point, that you can respond to this concern that the public are slightly, not adequately understanding and perhaps problematic in that sense when engaged with on these issues. Yeah.
I'll actually start with that, Nishan, because I think what Kanthi raised and what Dr. Pilapitiya raised actually sort of like aligns with the question that you raised. So I think it's a good starting point. So working in Environmental Foundation now, it's 2 years since I started work, and I've gone through quite my share of IEE reports, initial environment impact reports and environment impact reports. And to be honest, I am unable to understand the techniques. And what I try to do is within the legal division, what we always try to see is whether go through the guidelines and the legal framework and try to see whether the legal framework has been sort of complied with in terms of what they have covered. because the technical aspects and the identification of impacts, it's quite complex. And one point of complexity that comes in is something that I struggled when I started reading EIA reports is sometimes they have donor or when there are funded reports, when there are funding agencies, those funding agencies have their own environment impact assessment frameworks and regulatory frameworks that they voluntarily adhere to. And sometimes the EIA report also adheres to those frameworks. So clarification of whether this is an NEA regulated requirement that they are referring to in the report, or whether there is a funding agency requirement that they're complying with in the report, that itself becomes a little complicated if you have to, then you have to sort of familiarize yourself with that there are ADB funding organizations. For example, ADB would have their own requirements when they prepare the EIA report, which we have to sort of be aware of. So that awareness is lacking for sure. And I do agree that there is a level of sort of awareness creation that is lacking even within the CSOs when it comes to the grassroots level and connecting with the communities and explaining the entire process and what goes into the report. And in that, my concern is within 30 days, we ourselves struggle within our revisions to coordinate between ourselves and figure out how to comment to the document. And in that context, providing explanations and providing sort of guidance to the community and public who might be interested to support and who might be interested in actually putting out comments, it is really difficult for us to sort of be of any assistance. And one of the things that actually EFL has initiated is try to develop a template for public comments, so that this is a sort of a initiative by the science division, and we are trying to sort of develop a template of sorts so that people who are interested in commenting in the process can actually access that template and refer to the process. But going through the executive summary, this is a double-edged sword actually, whether you can make the report comprehensive and comprehensible, and whether that is in the advantage of doing it, because like, is it advantageous to actually make it simplified? In that case, making it simplified would actually, like, we would lose out some of the information that is critical for us to evaluate the project. So it might not be possible to make it comprehensible, and it is a scientific technical document. So how simple can you make it is also a question. And yes, in that regard, we have a role to play. The environmental organizations, the civil society organizations do have a very active role to play in actually reaching out to the public, informing that these comments are due, 30 days are due on this date. So if you're interested, please make the comment. So that's sort of like the I think connectivity that we can build up through the civil society, which perhaps is also lacking because of the time constraints, resource constraints, and also the gap between the civil society and the government. Because unless we are getting the information actively through the government agencies, we would also have to actively seek out the information, which will take 1 to 2 weeks. And in the process, we would have lost out the 1 month period that is due for public comments. Is there any questions, or can I make a couple of observations that... Yes. So moving on with, I'm actually like leading up from the observations.
I was on mute, Madhya. Yes, please go ahead. We are looking forward to your comments. Yeah.
Yes, thank you. Yeah. So one thing that I wanted to highlight is for the civil society organizations and public themselves, the public commenting and public participation is a critical thing to sort of like participate in the process and sort of to influence the decision making regarding these are basically planning decisions. It regards in UK law, in the UK legal context, EIA is considered as a part of the planning law actually. So the planning law is environmentally conscientious. But in Sri Lanka, it's the reverse, where environmental law is sort of playing a very active role in the planning decisions, which is plus, I would say. And EIA is actually a look before you leap kind of a situation where you're basically saying you need to make predictions or assumptions. So this is where the scientific expertise comes in, and the consultant's role is actually important. And I wanted to highlight what Ms. Kanthi highlighted in terms of the role of the industry and the consultant. And this is set out in the guidelines itself, the CEA guidelines regarding the environment impact assessment process provides specific guidelines to the developers And it states that it will be ultimately the developer's responsibility. The environmental report is ultimately the developer's responsibility, and therefore, when they negotiate what goes into the report, in addition to the TOR, which is prepared by the CEA, it is essential that they also go beyond the TOR to identify what types of impacts that there will be. For example, whatever biodiversity impacts, landslides, and also modern impacts such as like climate change. And being a party to the Paris Agreement, this is something that we have to increasingly look at, especially when it comes to our land use policy and building permits and such. So I'm just going to highlight 2 points basically. One thing is regarding the environment impact process. And since we are highlighting public participation and we've highlighted the importance of access to information, I wanted to just raise this concern that environmental law and compliance with environmental law cannot be expected in a bubble where in the civil society and the government and political environment where civil and political rights are not respected and procedural rights are not upheld. So in that context, I want to raise the crisis that we have in terms of constitutional governance, in terms of the lack of independent commissions and watering down of the independent commissions such as the Audit Commission, RTI Commission, Human Rights Commission. That plays a role automatically in watering down the impact and the ability of public to actually access information, and also the incentive for the government authorities to comply with the public information requests. And also it hinders the background that we need to have for effective environment impact assessment process and compliance with the process. So EIAs cannot stand alone in its own as a sustainable development tool. It has to be supplemented by procedural rights and human rights, a strong human rights regime. And especially that's why I wanted to highlight with this emergence of right to information into the Constitution and with the Right to Information Act, there has been a huge development in that arena. But until then, we didn't have right to information as a right. And what about public access to information then? So likewise, there is an importance for the constitutional governance and the governance structure to be of such that it promotes compliance. And the second thing I want to raise is updating the law and the governance regulations. I think Kanthi and Dr. Pilapitiya both raised this question. I just wanted to point down some of the key things that I think I have come across that ought to be updated, at least in my point of view. So one thing is regarding the prescribed projects, because projects were referred by a couple of questions also. The prescribed projects, as Kanthi mentioned, it's in the 7.2 Gazette under the NEA Act. And if they are not in the prescribed project list, it goes into the initial environment impact assessment. So prescribed projects need to be updated in terms of the development priorities that Sri Lanka has undergone, and also the prior experience that we have now over for 20 years. We have been implementing the same prescribed list for a couple of years, for 20 years actually. So as Dr. Sumith Pilapitiya mentioned, some of the things that are in the list, it refers to if there is a land clearing over 50 hectares, it needs to go into an EIA. So, and for hotels, 99 rooms or above need to go into an EIA. For energy development projects, for thermal plants, it's 50 megawatts. For renewable plants, it's 50 megawatts again. So what is the rationale for this is one question. And second is, do we need to update this depending on the changing circumstances and changing economic priorities we are facing? I don't want to take much time, so I'm just going to highlight the other key few points. The second issue is the discretion, the absolute discretion given in terms of the initial environment impact assessment process, because this is a area which is sort of a bit of a murky waters for us as well, working in the civil society sector, because we also don't know whether something goes for IEEs and what is the basis for it, because EIA and the process is extremely extensive and the details are in the guidelines. Once you get access to the guidelines, you can actually follow that process. But IEE is absolutely the discretion of the respective project agency. And we have seen instances where, especially in the Coast Conservation Act and the Coast Conservation Department, where there have been instances of abuse of the discretion as well. So in that context, we have to question how much of discretion we can give to the public and regulatory authorities and whether it is effective. Because in certain instances, because of these institutions being specialized agencies, having their own expertise, discretion is given with the belief that that expertise will be used to the maximum in order to benefit the specialized area. But in some instances, this political intervention and changing priorities, political priorities, do play a role in sort of abuse of this discretion as well. The third is very well explained by both Kanthi and Dr. Pilapitiya regarding monitoring and evaluation process, which needs to be sort of codified, regularized. It needs to go into the law, and the law needs to be updated in that regard, especially setting out what the CEA can do if the EIA process and the sort of the mitigation plan or the preventive plan is not met. What can the CEA do, and what is the process to follow after that? Third is regarding public hearings, and I need to actually commend the report that you guys have prepared under Verité on this, because you have sort of compared the public hearing process and highlighted that some of the countries who have actually sort of codified the requirement of public hearings as a compulsory requirement. So that should be done, because public hearings is a way to sort of actively make this entire public participation process a deliberative process. Otherwise, it's going to be a very passive tick in the box kind of a process that we follow. So in order to make it actually effective and actually for us to get some effect of the decisions and input that public can give, it has to be a public hearing, especially in the countries like Sri Lanka, due to our political, social context. The third thing I wanted to highlight was climate impacts and the need to sort of highlight and change in the law again to develop the system to actually look at climate impacts as well. This comes from our requirements. We are a party to the Paris Agreement, and we have prepared the nationally determined contributions under the Paris Agreement, and therefore we have a commitment to actually consider mitigation and adaptation plans and adaptation requirements for climate change and to address climate change. So one of the things that projects need to look into is how to actually mitigate the adverse impacts of climate change and the potential impacts of climate change as well. So with that, I will hand over to you again for questions and comments and clarificatory questions if you have any.
Thank you, Bhagya. I want to bring in the speakers and the researchers as well. So Subhashini, Mathisha, Uween. And after I ask one question that came out of the panel, I want them to take maybe kind of rapid questions, right? So 1 to 2 minutes for whoever wants to speak and respond to what the panelists said. That's how I'll run it. But before I get to them, give them their kind of 1 to 2 minutes each, let me just ask Kanthi or connect with something that I heard Kanthi and Bhagya both raise, which was this question of consultants. You know, Kanthi said that that these consultants are probably, not adequately competent was the concern that Kanthi had. And she explained this as both affecting maybe the readability and comprehensibility of the report, but also affecting the quality of the assessments that were done. And they had a lot of discretion, it seems, because they could increase the scope. So having competent consultants seems quite important. And there is a question from the audience as well that asks, well, who appoints these consultants? How's that done? And then I think we'll go to Sumith in answering that question also to say, well, is it the problem that Sri Lanka doesn't have adequately competent consultants? What is this? Is this a solvable problem? How would we solve the problem of good enough consultants, I think is the question. We'll start with Kanthi and then perhaps go to Sumith. And then come to Uween and Mathisha and others and Subhashini actually to also ask their questions of the panel. Kanthi, I don't have you on video, but that's okay. If you're even on audio, you're welcome to come in at the moment. Yeah.
Okay. Now, in fact, the regulator or the Central Environmental Authority does not get involved in selecting the consultants because it's not the job of the CEA. So we issue the terms of reference to the project proponent. So project proponent is responsible in submitting the EIA report to the CEA. So we don't have any business with the consultants. So it is the project proponent who selects the consultants. So, but for the convenience of the, for the project proponents, the Central Environmental maintains a list of consultants who have expressed their willingness to prepare EIA reports. So we haven't done any kind of assessment to determine that which consultants are better than the other consultants, because CA does not have powers under the National Environmental Act to do any assessment about the consultants. So we just maintain a list of consultants who have expressed willingness to carry out EIAs, and if the project proponents inquire about consultants, we just issue the consultants. We do not recommend anybody to the project proponent.
I understand. So I think, let me, but do you blacklist any consultants, just as a quick follow-up, Kanthi?
No, we do not even blacklist.
So even if you find a poor job done and it's not adequate, you don't have a system of blacklisting consultants either.
No.
Sumith, I don't know what is done elsewhere in the world. Can the person who's interdicted, be paying the judge? Is it okay for the project proponent to be paying the consultant and selecting the consultant? If that is what happens, is there any other model that's better? How do you see the consultant competence problem in Sri Lanka and the solution towards it? So I'm also interested in asking, are there solutions that we could be talking about in this respect?
Yes, I think there are solutions. One of the biggest, well, I personally don't think that capacity is a huge consultant's technical capacity is a huge problem. It is somewhat of a problem, but it's not a huge problem. Because the same consultants who will prepare a shoddy EIA for a government agency, the same consultants have prepared excellent EIAs for the World Bank. So that is not a capacity problem, right? The biggest problem is the fact that sometimes there is the consultants, okay, which they shouldn't be doing, but they compromise their professionality by giving into pressure of the developer who is paying.
We may have temporarily lost your voice if you can hear us. Yeah.
Refuse to do that.
Now we can hear you.
Can you hear me now?
Now we can hear you. Yes.
Oh, okay. Sorry. What I was trying to say is more than the capacity of the consultant. It is. I'm not saying that technical capacity of consultants in Sri Lanka is excellent, but there is good enough capacity for us to do what we want to do. Like I said before, you may not have heard me. The same consultants, individuals who prepare a lousy EIA for a government agency prepares a very good one for the EIA. So then it's not a capacity problem.
Back to my question, whether the consultant being paid by the developer is the appropriate model.
That I feel that is one of the biggest problems we are having. That's why the quality of the EIA is no good. Because the developer won't hire the consultant or pay the consultant unless the writes what the developer wants to a certain extent, not to some extent that happens. A model that could be done is, I don't know whether the government is interested in doing that. Consultant could be, the developer could be told, okay, let's assume conducting an EIA for this type of project is 5 million rupees. Deposit the 5 million rupees in an account in the Central Environmental Authority. CEA will hire the consultant. So who will prepare a report that is much more independent. That allows the consultant to be a little more independent, right? So that is one option of looking at it. Or the other option is, if the government is very strict about the quality that you approve, also the consultants, the quality of the report goes up, right? So there is problems on both sides. So I think we have to be much more stringent about the quality of what we accept from consultants, even though the developer is funding. The ideal situation would be to go for a fund where the developer puts the money in and the CEA or some recruits the consultant to do an independent job. Politically, I don't know whether the CEA will ever get to do that, because all the government agencies will go against them when they try to do that.
Yes. Thank you. So there are models to think about that help
Yes.
to get the consultant actually to be acting more independently and more professionally.
And then there's another thing that can be done. The CEA generally invites the technical working group or the evaluation committee. Many times people are invited by the organization they represent. I really feel what they should do is invite people to the TEC on the competence you represent, rather than the organization. So that, and the more independent people you have in a committee, the easier it is for the evaluation. I think even the CEA will find it easier, because you can always blame the independent members of the committee saying that they are refusing, even if there's political pressure, because many independent members won't compromise. So there are ways and means of dealing with it. But the CEA, Kanthi herself, has told me sometimes when we invite outside experts to participate, they refuse. So that also is a problem that the CEA faces. So we need to address these things. That's why I said we should have a serious discussion about the EIA process with a intent to try to improve the process with all the stakeholders.
Thank you, Sumith. So that's helpful, and that's a good intervention on that question of consultants and what their incentives are, and how that has an impact on the outcome. Shall I start with Uween, Mathisha, Subhashini? And if you don't have a question, you can pass. But otherwise, or a comment, otherwise you have a 2-minute. I'll give you just 2-minute responses or questions to carry us forward. Y'all maybe on mute, guys. Yeah. So if you want to, otherwise,
until Mathisha and Uween think about what to say, I will just because there was a lot of questions and concerns about the political will, and then the answer is, how do you move political will? What is the force that can move political will? But whose opinion would the politician care for? Do they care for Nishan's opinion and my opinion, or the CEA opinion, or a bunch of scientists' opinions, or do they care about public opinion? To me, yes, there can be concerns, but if there is any force that can move political will, that is the public opinion and the public demand for better compliance, better governance. And that is exactly where we feel, although there are concerns, or the public will, make unnecessary complaints, or they're not effectively engaging, but it is also our fault, like we have identified, that if we are not giving them the right information in a manner that is easy to understand, then obviously we can't have effective public participation. But giving information and encouraging public participation, I feel public has the ability to move political will, and that is an important point that we need to highlight and remember when we are talking about moving politicians to behave better. That is an important thing not to forget.
So I think Subhashini's point there, and I think it may be worth for Kanthi and Sumith to again respond. Sorry, Bhagya. It's a point that Bhagya made also. She said access to information is poor. And I think, and that's of course the meat of much of the presentations also. So, there was a sense I got, Kanthi and Sumith, that you felt that it was, 95% a political will problem and a political support problem. But can we really blame the politicians for the lack of information that the public have, or the lack of disclosure of the available information? And Subhashini's point is, the public could be really mobilized to help hold back the politicians through better information disclosure. So maybe this is a strategy that the bureaucracy should think about, that the public can become that safety, right? Because the bureaucrat can't tell the politicians to step back. But if the bureaucrat provided the public the right information, then public concern itself may cause the politician to step back. And I think that's an important sort of strategic thought that's being put forward. I'd love to hear the response from both of you. Yeah.
Yeah. In fact, actually, I have to respond to this question from the point of view of the regulator. In fact, actually, the Central Environmental Authority always actually promotes the public consultation, because we believe that the public comments are useful and they are actually strengthening the position of the CEA, because certain aspects we have to understand that the government officers will not be able to pressurize the government in certain aspects, but we believe that our position is being strengthened by the public protest and the public comments, so that I am always actually encouraging the public comments. But the problem is, we are worried that we don't get adequate public comments during this mandatory public commenting period. It's actually a sad story. So that's another thing. But I have to actually, I admit that the ineffective this public participation is mainly due to this poor quality EIA reports. It's actually not understandable, this EIA reports. So I believe that the NGOs like this Bhagya and other organizations and interested groups can do a lot in making the general public aware of the projects. I heard very recently there was this kind of awareness program conducted by one of the NGOs. That was very good, in fact. So then actually the people can understand the real situation and the real problems of the project. So in fact, actually the government agencies or the CEA cannot do anything to make the people aware of the project, because actually if the CEA get involved in such activities, CEA can't be a kind of an impartial person then. So it has to be done by an independent group like NGOs. So I think NGOs can do this and to make this public participation very effective.
So thank you. While you're saying that public participation can work better, but we do go around in circles a little bit, don't we? I think public participation can help a lot, but quality of public participation is poor. Then Bhagya also may want to come into this. Bhagya says, well, information disclosure is poor. So maybe we'll ask Sumith to try to kind of show us the middle ground here. Yeah.
Well, I also am a very strong believer that there should be extensive public participation in the EIA process. I think one of the problems the public faces also is a 300-page EIA, which is in highly technical language, trying to understand that. It is much better if the role that the CEA can do is the CEA could try to insist on public hearings of projects. If you have more public hearings, the public will participate more rather than reading some document and sending comments. And I know that if there is adequate interest, the CEA can ask the developer to have a public hearing or several public hearings. I think that would be something that should be stressed more from the CEA side. It should become more of a requirement, because that will ensure better engagement of the public in this whole process. And I agree with Subhashini 100% about public support, because let me tell you, again, going back to the Mattala, in that plan for this managed elephant reserve, for 10 years, the wildlife department was pushing for that to be declared as a MER. Dr. Prithviraj Fernando and I, as individuals, were pushing it for 10 years. The short time I was DG, I was pushing it, and I couldn't get it done. Farmers go on strike for 100 days and it is done. So that shows the power of public protest. So public involvement, I think, is the best way to make politicians want to do the right thing. Because certain politicians who came and tried to support the public there were the same politicians Prutu and I have been speaking to, and who said, no, they are not supporting the MER. With the demonstration, they were up front in front of the TV supporting the MER. So it's really a very valid point. We have to try to get much more public involvement. And hearings, I think, is the first step towards that.
So thank you very much. And I think Chandrajaratna made a comment that in addition to that, for the EIA, for the Central Environmental Authority, that putting EIAs for independent review or having the CEA's own review panel on EIAs could also act as a check against consultants not being more conscientious, because I think now if they're giving good reports to the World Bank, that's because they know the World Bank is going to internally review it. and take exception to poor quality reports. So some kind of independent review process, I think, was the point that was being raised that could also potentially help. I can see a hand up from Mathisha and Uween. Do you want to come in with a question?
Yeah, Nishan, I just want to sort of highlight, as much as we talk a lot about public participation, I believe the discussion has sort of surrounded mostly the EIA preparing and the EIA process itself. But I think, as Ms. Kanthi was quite rightly pointed out, when it comes to the audit process or even the monitoring process in Sri Lanka, it's almost non-existent. And I just want to I know we didn't talk specifically about it during the course of the presentation, but I would just like to hear what maybe the panelists have to say, particularly about how weak monitoring and auditing is in Sri Lanka. And even in our study, what we've done is we've looked at some of how the other countries do it, and we see that there is actually a lot of space for the public to actually get involved in the monitoring and auditing also. So it's not just about preparation, it's also about being able to actually hold people account to the reports that they've actually produced. So just want to get a sense of...
I'm going to turn the question back on you, because the panelists already told us that each of them highlighted that in different ways how monitoring didn't happen. So I think Kanthi said it's not required by the law. The CE has no jurisdiction as such. That there is no way to that. I think others said how when RDA does gets the EIA, they give it to a subcontractor. The subcontractor isn't told about the monitoring and evaluation or the compliance side of it. So is there a problem in the law? And maybe Sumith also can help answer, or Bhagya can answer, since Bhagya is a lawyer as well. Should the law itself be changed to allow for this? Is it a problem in the law? Is it a problem in, from what Kanthi said, it seems like the CIA is interested, but is slightly held back by a lack of a legal framework to be proactive in this regard. So quickly on the law, perhaps, maybe Bhagya first, and then Uween and Sumith, and Kanthi, if you want to add anything to that question. Yeah.
Yes, definitely. This is something that the law needs to update on, certainly, because the NEA provides the general framework of, since we didn't discuss the legal background of the EIAs, I'll just give you a brief overview. So basically, the National Environment Act provides the general legal framework. It's an overarching framework. It doesn't have the fleshed out step-by-step process. It just gives you need to do an EIA. It will be monitored by the Central Environment Authority, and the minister has the power to make guidelines. And the key documents in regards to the steps of the EIA process are in the Gazette notifications, which sets out the prescribed projects and the project approving agencies. And thereafter, the steps of the EIA process, how to conduct the scoping, how to conduct the public hearings, in what stage can the public participate, that detailed steps are in the 3 guidance documents published by the Central Environment Authority. One issue is all the project approving agencies are using the same set of guidelines developed by the Central Environment Authority. None of the developing agencies, we have done our research, they have not adopted their own different guidelines or guidance documents. What they refer to is the CEA guidance documents. And in here, the monitoring and evaluation at that time, perhaps because these documents, the latest guidance documents was made in 2003. And therefore, at that time, perhaps it was not a key priority as it is now. But monitoring and evaluation as a step-by-step, who will be responsible, what are the steps of the Central Environment Authority, and what will the jurisdiction of the Central Environment Authority be in monitoring, and what can they do in terms of monitoring the steps, in terms of the mitigation or preventive measures that are suggested in the project, is not set out in the legal framework. And therefore, there is an inadequacy in terms of triggering that jurisdiction of the Central Environment Authority altogether as the main regulator regarding the monitoring and evaluation and EIA process.
Thank you for that. And Uween, did you have anything to add to Bhagya, or can I just...
Yeah, definitely resonate everything. I want to echo everything that Bhagya has said. In fact, she quite correctly pointed out there isn't any kind of specific legal provision. Of course, like to me, I kind of sometimes do wonder, because if one were to look at perhaps the powers that are vested in the Central Environmental Authority, and the powers perhaps given to the Director General under the Coastal Conservation Department, the language used in sort of describing the scope of these powers is quite large, it's quite broad. I'm just wondering whether whether that level of power that's actually vested in these institutions can be actually used proactively, or sort of given a progressive interpretation to actually carry out monitoring and auditing, because it is understood that you do the environmental impact assessment report with the purpose of it being complied with. It's sort of a given, it's sort of understood. So I'm just wondering whether, given that the institutions do have powers to conduct investigations, powers to, inquire into certain things, powers to actually conduct site visits, I'm wondering whether that framework can actually even be used, and using
Yes,
that is
I
basically
got
the
it, Uween.
problem
So
with
you're
the
effectively
institutions
saying,
itself.
why can't the CEA have more proactive initiative on this? They don't need to be required by the law, but the law does provide them adequate mandate to exercise if they were proactive. And Kanthi, maybe you want to come in quickly on that question? Yeah.
Before
In
Kanthi
fact,
answers,
Yes,
quickly say
Kanthi, there's a
something
lot of
because
interest in
I'm
answering
going
this
to put
question.
Kanthi more on the spot by my comment
Go ahead.
also. So let her
Okay,
answer everything.
go ahead. Yeah.
So I'm not a lawyer, but
Okay.
isn't the environment EIA clearance letter a legally binding document that the developer has to comply with? So into that, why can't you say that you need to have a monitoring plan? You have to have an environmental management plan. I see those things in certain EIA clearance letters. And the problem is the CEA doesn't make the EIA clearance letter a public document. If you make that a public document, there'll be people like Bhagya who will take the developer to court for not complying. But as long as it is a confidential document, you can't do anything. Sorry, Kanthi, I'm putting you on the spot on this.
That's the same point I totally as well. I totally agree with Dr. Pilapitiya. In fact, actually, though the provisions are not included in the law, we actually impose these requirements in the environmental approval issued to the developers. So the developer is responsible for submission of the detailed environmental management plans and to carry out self-monitoring activities and provide monitoring reports to the Central Environmental Authority. So the CEA will do third-party monitoring also in between. So it's true that if we can make the environmental approval letter a public document, so these NGOs can take action. In fact, I do totally agree with you, Doctor.
So that's a great solution kind of potential there, I think. Yes. And I think the strategy, right, that where the bureaucrats are limited by providing information, they empower the public to kind of change the political incentives is something that's coming out as an important thing. I just want to say, before Subhashini comes in again, I want to say one to Sumith, Sumith Pilapitiya's point that public consultation really helps. I was a regulator also. I served on the PUCSL, and when we had public consultations, you'd be surprised. We planned for maybe 200. We had 500 people. It cost a lot on the food budget, but it was really quite amazing how interested people were. And we are required to, one of the guidances we have is that we can call public consultations, and we use that guidance to proactively call for public consultations, sometimes not even on a specific project, on the whole direction of policy for the country. And it was extremely important that environmental issues came up rather a lot in these public consultations as important issues. And of course, CEB and others were present. But I want to talk about one other opportunity. By example, perhaps you can say more now. One of the ways that Norochale power plant's non-mitigation has been kind of taken to task is the requirement of a provincial environmental clearance that's required to be updated every year. They need an environmental permit, if I'm not mistaken. And of course, they because they haven't done the mitigation, they can't get the permit. But because they're too big to fail, the courts also have given a separate option rather than shutting them down. And I think Bhagya and others perhaps your institutions have been responsible for even taking them to court on these issues, right? So is there another device like that where you have to renew your environmental clearance annually, and that renewal process then subjects you to scrutiny and ensures compliance on an environmental mitigation plan? So some quick responses on that, and then I'm sure Subhashini has more questions, and I'll move to her. Yeah, Kanthi, maybe you first.
Yes. In fact, actually, there's another tool that is the environmental protection license, so which can be used to do monitoring during the operational period of the project. That's a kind of an annual requirement.
Yeah. So that's another one in addition to the public consultations, and that in addition to making the letter of authority available to the public.
So in fact, the Central Environmental Authority needs to go and check all these emissions and the waste discharges, whether they meet the standards prior to issuing the license.
Right. And the license can be an annual renewable license.
Yes, it's annual renewable license. But with respect to Norachole, of course, it's the Northwestern Provincial Environment Authority who is responsible for issuing this license.
But it's I thought quite impressive that authority did not give the license, and that this has held back the license because of the failures, and court has taken it on. So that's Bhagya, did you want to come in on that?
Yes, I just wanted to step in a little bit.
I'm more optimistic on the whole issue,
not on this issue, unfortunately. So regarding the EPL licenses and the site visits that CEA conducted, so I have come across a number of site visit reports that CEA has conducted and has observed violation of EPL conditions. However, regarding the observed violations, what are the post sort of compliance measures taken, whether they have been sort of taken to task after notifying or sort of investigating these violations? That is a question that is unanswered, and I have followed up on through RTI requests also what action has been taken, and those RTIs have not been responded to. So on a personal scale, I have followed up on a couple of projects regarding where EPL conditions violations have been noticed and condition violation letters have been issued by the CEA. However, nothing has been done, and the project still is continuing in constructions, and project is ongoing. So this has happened in instances where the project is taken to court, and in instances where there has been a public outcry against the project itself. So in that regard, there is a problem. That's why I sort of mentioned that this has to go into the regulation, because Sri Lankan culture is such, Sri Lankan bureaucratic system is such. Unless we empower the bureaucrats with some legal provision to say you are under a statutory duty to take action on these specific violations, I don't think it is successful for us to sort of expect that the bureaucrats will rise up to the occasion and sort of become guardians of environment or social justice in that regard, because of the bureaucratic and the statutory structure that we have, especially the constitutional governance structure we have, because we have a very strong statute setting out the exact limits of the CEA, and then when you don't have any of the monitoring and inspection powers specifically pointed out, of course, resource requirements and other requirements and constraints might play into sort of not following up with the observed violations as well. Regarding Norachole, since you asked me the question, I will have to step in. So we went to court against the EPL violations, the conditions were violated, and we were in the sort of process of obtaining leave to proceed with the application for about 5 years, and after a 3 years battle in court, we've had consultations with the Norachole Power Plant and the NWP, Northwestern Province Environment Authority. However, the plant is ongoing, and the condition violations that we've observed are continuing, and despite that, of course, there has been no effect in terms of how the plant has sort of adapted. But I should note that on certain terms, on certain conditions violations that have been notified, they have taken some actions after the court case and some of the consultations that were made. So I don't think we can expect 100% compliance at this rate, because even we are sort of like treading around murky waters in these issues. And the second thing I have to notice, like despite the existing violations of the conditions and despite the existing violations that have been taken to court, the second plant expansion is also now underway. The feasibility studies are being done and the EIA is being conducted. So this is one of the issues, is that when it comes to a provincial level authority, yes, the oversight is quite closer in terms of the geography and the context, but also there is a sort of an overlap now, isn't it? Because we have the Central Environment Authority, centrally the regulator, and then we have a provincial authority that is now taken up the task of becoming the regulator for the specific province alone. So I think in that context, we also get confused as to, will the Central Environment Authority step in this regard, or is it just the Northwestern Provincial Authority? And also I have huge questions. I have serious questions regarding the capacity, technical ability, and the expertise, and the resource capacity that the Northwestern Province itself has, because the CEA has decades worth of experience and institutional knowledge regarding carrying out environment impact assessments and EPL licenses. And how is that coordinated? Because this is an added step of coordination as well. So I think institutionally this is a huge issue, and even legally it's an issue that sort of, as a lawyer, I am concerned about with the 13th Amendment and the constitutional governance of the country. How is that playing out, that one province alone has a statute that governs their environment, and under that they are carrying out EPL and EIAs by themselves? And that makes a big problem for us as watchdog organizations, and I think even for the regulators in the central regulation system. Thank you.
So let me just come in briefly on that, because you didn't raise a question for the panelists per se. I think of all what central authorities do in well-devolved systems is that the central authority really equips the devolved institutes with the capacity, so that, say, the Northwestern Province should be able to come to the CEA and say, help us do this. And the CEA will have the resources even to contribute the technical knowledge, and will continue to build capacity in the devolved institutions, but act as a place that can actually deliver that service, even though the final issuing authority may be the Northwestern Province. It doesn't have to be always the doing authority. Exactly. Right? And that's why you have strong, powerful, competent central institutions, because the knowledge, know-how, ability, services can still come from the center, even when the decision needs to be. So what it does is prevent national politicians overriding local concerns, and local politicians pay a higher price, as Sumith said, if you override the public concerns. So when public concerns become surfaced and discussed, which I think the provincial government is able to do, I mean, that may be just theory, but I just want to kind of locate that it's not a deal breaker. That a province does not have the ability. It should never be a deal breaker, I think. Sumith seems to be wanting to say something. So I just switched to Sumith, and then Subhashini, maybe you want to come in and raise one more round of questions. Yes. Go ahead, Sumith. Yeah.
Just about the provincial and the central
yes.
regulators. See, the model of the Northwestern Province is not the best possible model, because if you are doing that, really inter-provincial environmental issues should be the responsibility of the center. Intra-provincial environmental issues should be the responsibility of the province. But that is not what has happened. That's why there is this tug of war almost of between the two agencies, the CEA and the Provincial Environmental Authority. But that's what should have happened. If that happened,
that's right. Environment is not a contained issue.
And capacity also would be much addressed in a much better way.
Yeah, in fact, actually, that's a constitutional issue. In fact, actually, the CEA does not have power to resolve that issue.
Except from a policy perspective, I suppose.
Yes.
Because national policy on environment is still with the CEA. Subhashini, do you want to come in with maybe a last question, or perhaps otherwise you want to come in summarizing later? I just want to give you the floor for a minute to pull things together.
Thank you. I think I would really like to thank the panelists for the fabulous comments and observations. Again, what is really valuable here is understanding about the political pressure, I guess, where there is the discretion and the power government authorities have can be used for to enhance governance as well as to accommodate political interests, right? But I think bureaucrats always find it challenging and difficult to do, to further enhance the governance side. Whereas they're forced to really accommodate. I think discretion is more often than not is used to accommodate political interests, compromising the governance. So maybe that is where what Bhagia says becomes really more important, that actually having it in law, in black and white printed, and saying the bureaucrat can't do anything else other than be compliant may be a better way, especially in Sri Lankan context, where political pressure, especially to fast track projects. I know the conversations with bureaucrats often say they're under tremendous pressure, not just with the Central Environment Authority, but at every place that they're under tremendous pressure to fast track, short circuit the systems. And it is unfortunate because we are thinking of projects that can affect generations, and to think that we feel spending more time to ensure that that the environment is safeguarded is thought like a waste or unnecessary. It is unnecessary burden. Is an unfortunate attitude towards the entire process, especially when we live in a world where the adverse consequences of our previous generations not caring about the environment is felt by our generation. And we are continuing to do the same thing without caring about the future generation. I always like this quote that says the earth is, we have not inherited the earth from our ancestors, we have borrowed it from our future generation. And when you do borrow, what you do, you want to return it in the same way. Right. So whatever you borrow, you want to return it in the same way. So I think that is why we are talking about sustainable development and environment. But you can feel that Sri Lankan public cares about environment quite a lot. Most of the recent debates and discussions indicate that they do care and they do worry about it. So I feel I think we have a window of opportunity to really utilize that public concern, public interest to fix some of these problems. And like Kanthi and Dr. Pilapitiya said, also the CSOs and research organizations and scientists have a bigger role to play, I feel, to educate the public, to work with the public, to really help. So that is why we focused our research, or at least presenting parts of our research that focused more on information disclosure and public participation, because we also felt that the current problem cannot really purely be fixed by bureaucrats and researchers alone. So that's all from my end. I don't have any further questions. Nishan, over to you.
No problem. Maybe if there's any kind of 1.5 minute last comment any of the panelists want to make, I don't want to put you on the spot, but if you feel like you had a thought, you didn't get to share it yet, maybe take this next 1 minute and I'll close us at 5 p.m. Yeah.
I would like to make just a comment to something Bhagia said about the donor requirements for EIAs and the government requirements. The easiest way of solving that is for the donor what we used to do when I was in the World Bank also, we used to sit with the CEA and come up with one TOR that covers the donor requirement as well as the CEA requirements. So then there is no confusion of two EIA reports and one wanting more and one wanting less. That is the EIA that has been cleared. I think that is one way of.
Thank you, Sumith. Did anyone else want to make? Kanthi, you wanted to make a comment?
No, in fact, actually, what I want to say is the EIA process cannot resolve, the process alone cannot resolve everything. It has to be supplemented with other processes. Something like, what I feel is there should be a procedure to evaluate the technical and economic feasibilities of the project. But I believe is, I don't know if the National Planning Department is at present doing that job. So that is a serious issue, because there were some allegations about the Umaoya project during the presentations. But what I feel is actually mainly the problems there are related to the technical feasibilities, not the environmental aspects, basically, because they have planned, they have actually implemented the project without carrying out any technical feasibility of the area. And they have implemented the tunneling activities without carrying out the suitability and the feasibility of the tunneling in the area. So those things need to be actually considered by another process or another agency. But what I feel is the National Planning Department need to be strengthened to assess especially the feasibility of these public sector projects prior to the EIA procedure. So
Thank
EIA,
you very much.
Yeah.
Thank you. Yeah.
Yes.
Bhagya, you may also, I think.
Yes, I have a small comment to make regarding that, like regarding the planning and sort of looking at EIA and also like regulation in a general perspective. What came into my mind was regarding Orochole power plant and Kailani River pollution, and even regarding institutions. One of the things that we have followed very closely at the EFL is the Audit Commission reports commissioned by the Auditor General's Department. Under the 17th Amendment, when the Audit Commission was functioning as an independent authority, there was a huge number of the reports that came across regarding nationally important projects that looked at the environmental impacts and also the economic impacts of the report. So there was separate reports prepared by the Environmental Audit Committee and the General Audit Committee separately. So that this again comes into that what I highlighted regarding the constitutional governance and the general rights and importance of having that strong procedural right system, like right to information, access to information, equality, and having independent institutions and having a strong constitutional governance regime and independence of the public authorities and public judiciary being entrenched in the constitution, and respect for that is important. And I also wanted to make a small comment about litigation and environmental impact assessments, which wasn't raised actually. I will raise that right now, because this is one misconception that public has most of the time, and I have dealt with this quite extensively. The fact that EIA can be challenged at court, and the EIA process can be challenged at court, not the EIA itself. So the quality of the EIA, what we highlighted regarding the consultants, what they do, what goes into the report, the mitigation plans and the many plans, whether it is not there out there, that cannot be challenged at the court because it is entirely the regulators' purview. And no court will actually go into look into the quality of the EIA report and sort of suggest recommendations or try to caution EIA report because it doesn't meet required standards, because court doesn't assume to have that expertise and technical capacity. That technical capacity is with the specific regulator. So what court looks at and what the law looks at is the process, and perhaps this is why I have been highlighting the legal process and the need to update the laws and the steps in the EIA process to be clearer, set out in the legislations, because I'm looking at it as a public interest litigation organization, and having that in the law, because process is only what we can question in litigation, not the content of it. And that is why it's all the more important that public involves and all the other CSOs are involved, and there is a willingness, political and institutional, to sort of make a good quality EIA report.
Yeah. Thank you very much. I think let me just say, I'm not going to summarize the presentations because the documents are there and we'll probably show them on the screen. You can download and read them as well again to remind yourselves. But, 4 very important aspects came out, I think, in the panel discussion. One that, one of obviously followed the presentations on the law, and Bhagya just highlighted how the law can be improved in more than one dimension, in requiring monitoring and evaluation to what the litigation processes are. And I think that requires a special set of focus and thinking about what is it that we can do with the law. But I think the other thing that came out was also that the process itself can be improved, quite apart from the law. So seeing it as a planning tool, not as an approval tool. I think Kanthi made that point very important. Having a process for follow-up and monitoring and evaluation that feeds back into maybe renewing the environmental licenses every year. So there are lots of processes within the law. There's space for improving the process. And of course, competence of consultants can be improved. I think Sumith said there are competent consultants, not that they're as competent, but more consultants, more clarity about competence, and the quality, and of course the incentives can be improved for everybody. The consultants also, that you improve incentives by subjecting them to perhaps third-party review, as I think Chandra said from the audience. By having a process to potentially blacklist consultants who do a poor job, by creating a different way of paying the consultants, not through the project proponent, but through the CEA that got the funding, which is what Sumith suggested. So there's a bunch of ways in which the incentive structures can also be changed, in addition to process, competence, and law. But I think one of the central tensions that came out today was the tension between the public interest and the political interest. And that the political and that the CEA or the bureaucrats were squeezed between these two. And I think one of the central insights might be that there's a way out of that squeeze, that the public interest can become the political interest when there's enough information with the public to hold politicians more accountable. And Sumith said how the very politicians who wanted the project became those who were opposed to the projects once the public interest changed. And I think this may be a very important strategy that Subhashini also highlighted, and Mathisha's presentation on information also highlighted along with Bhagya, that if the bureaucracy sees the public as helping them to overcome that tension or authorizing the contract. So I think perhaps the mind shift here is for the bureaucracy not to see the public as a problem, but the public as they're actually being a tool on the side of the bureaucracy to change political incentives and political interest in a way that is better for governance and better for the outcomes of society. So I think it was a very interesting discussion, and I think you guys in the panel, Sumith, Kanthi, and Bhagya, you all made it really quite exciting in terms of the discussion and the depth of knowledge and thought that you brought in. So I want to thank you very much. Thank maybe also our presenters, Uween and Mathisha, and Subhashini, who's led this research all the way. So I'll bring us to a close with that. I want to thank all the people who joined us on Facebook, joined us on this call as well. And we will have a separate event, this slightly sort of compacted version of this available on YouTube so that you can share with others going forward. So thanks, guys, and say goodbye to everybody who joined us today.